Thank you. Good morning, ladies and gentlemen. I hope that you enjoyed your unexpected 4-day weekend. I hope that nobody is too badly impacted by the storm that swept through. And we are ready to proceed. And we're picking up with Mr. Sprinkle, who was on the stand, I don't know, early last week maybe. But anyway, go ahead, Ms. Love.
Thank you, Your Honor. And good morning, DDA Sprinkle. How are you?
Very well. How are you?
I'm good, thank you. So when we last left off, you were explaining to the jury regarding the investigation into the murder of Donovan Thomas, the additional steps that you took in determining what to do with the file once you received it from the Atlanta Police Department.
Right.
All right. And you had explained that there were jail calls that you were able to listen to make certain determinations regarding information that was a part of the file.
Can y'all hear her okay? Everybody can hear her? Okay. Where'd your lapel mic go?
Would you rather, okay, even at the podium?
I don't know. It just seems, if everybody can hear her, that's fine. It just didn't seem as loud. Go
Okay.
ahead.
I can grab it now.
Maybe while he's answering, you can hook it up.
I don't think I can do both of those. This is a difficult contraption. I'll talk into the microphone.
Okay.
All right. So, Mr. Sprinkle, with respect to Spencer Wright, or the person that Detective Thorpe spoke to before taking out the warrants and the jail call that you listened to,
Correct.
Is my memory correct that you said that Detective Investigator David White was the person who then spoke with or went out and reached out to the person that Mr. Wright called from the Atlanta City Jail?
That is correct.
And the information that you received or that you were able to gain from that phone call made from the Atlanta City Jail, what impact did it have on your investigation into the murder of Donovan Thomas?
It corroborated what I already believed, which was that Spencer Wright, who initially provided the name of Nicholas Robb.
I'm going to object to that testimony. As to relevance, his belief is not relevant.
Sustained.
So as a result of the information that you got from that phone call, with respect to information that would assist you further in the investigation, what did you do after you listened to the phone call and had Detective White speak to Mr. Smalls?
Well, I spoke with Detective White. Well, broadly, I just embarked on the investigation of the murder of Donovan Thomas, because at that point I was essentially I was certainly without sufficient evidence.
Okay.
I can no longer rely on that statement.
All right. Now, at the time that you got the file, had Kenneth Copeland already been interviewed?
He had been.
All right. And when you reviewed that, those interviews of Kenneth Copeland, did you endeavor to speak with him anymore, or did you gain more information from the interviews themselves that assisted you in your investigation?
Well, as the investigation, as the months went by, I did desire to speak with Kenneth Copeland. but that did not happen. He he wasn't willing to speak with me.
How many of his interviews did you have at your disposal?
Well, I believe there were 3. There was one in particular from June of 2015. That
Is that
was
the 9-hour interview?
that would be the 9-hour one.
All
Yes.
right. Did you set out to corroborate anything that you
Objection, Esther
found?
Leading.
I'm sorry.
Sustained,
Yeah, I didn't hear the objection, so that. I can make sure-
leading.
Oh, okay. With respect to the Kenneth Copeland interview, did you take it at face value, everything that you heard in the interviews, or did you do anything to decide how you would treat the information?
Well, on listening to the interview and taking notes, I endeavored to corroborate as much of his statement as I could.
Did that involve listening to other interviews and jail calls as well?
Yes.
Would you tell the jury what other interviews you listened to without talking about what was said in the interviews themselves?
Sure. Well, there was the interview of Demiki and Garlington. There was an interview of Quindarius Zachary. And when I say there was an interview, I'm contemplating in my mind that there was only the one, but it is possible there were perhaps 2 or even 3 interviews. But I'm only recalling off the top. They may have all just run together as I listened to them. But as far as I know, there was at least one interview of everybody that I'm mentioning right now.
Okay. And with respect to Quindarius Zachary, did you take part in a 2017 proffer of Quindarius Zachary or include that as a part of your file?
I did, and it was recorded. I have it on a disc over here as well.
All right. And did you also listen to the August 2015 interview of Mr. Zachary?
I believe so. Yes, that would be the one.
Would you tell the jury what cell phone records or what cell phone numbers you found of interest after listening to the interviews?
Well, there would probably be a few, but I do, and I can't recall at the top of my head what specific cell phone numbers were mentioned during each interview. For example, depending on the interview, the party may have identified their own cell phone number or somebody else's cell phone number. But the numbers that were primarily of interest to me were those for which Detective Tyrone Dennis obtained phone records.
Mhm.
And the numbers that he obtained, I believe, were primarily, if not exclusively, from either A, the interviews that he conducted, or B, from cell phones that he found during the course of his investigation. He was able to forensically analyze and extract the number therefrom.
Now, you mentioned last time you were on the stand, getting the videos or the surveillance videos enhanced, the ones from the Texaco and the barbershop.
Yes.
Was there any other surveillance footage that you were able to obtain that was not a part of the original file that Mr. Detective Thorpe gave to you? Is the surveillance footage from the Texaco and the barbershop the surveillance footage that you used in making your decisions about what to look for next in this case?
From what I recall, I was primarily, if not exclusively, focused on the surveillance footage from the Texaco and the barbershop.
Okay. Who had you listened to the interviews from by the time that you did go into and look at the surveillance footage from the Texaco and from the barbershop, or did you do that first?
Well, so I watched the surveillance footage many times. I'm sure I listened to while I was watching the interviews, I watched various parts of the footage. After I watched the interviews, I watched various parts of the footage. It wasn't as regimented as I had like a checklist where I watched the videos and then I watched the interviews, and I would keep revisiting things as I went through the case file.
Other than looking for someone in a particular place like a park bench in the surveillance footage, what was it that the surveillance footage was able to give to you that you found of value in this investigation?
Well,
I'm going to object to the form of the question. What he found of value is not relevant, and I would ask that
I can rephrase.
Okay, thank you.
What from the surveillance footage were you able to utilize in furthering your investigation?
Well, first of all, it marked the time, the exact time of the homicide, which broadly is just very important because it allows me to establish a time.
Objection again to the testimony. What he found to be important is not relevant. I'd ask that be struck.
Your Honor, I'd ask permission to respond. With respect to what DDA Sprinkle did in gaining information about this homicide, as with any other witness, we'd ask that the court allow him to give the jury insight into how he gained the information that he got and made the decisions that he made.
Okay, let's just
Yeah.
stick to the facts without value judgments. Go ahead.
Okay. After you were able to get phone records, listen to the interviews, were you personally or your investigator able to obtain social media records?
Yes.
How did you decide which social media records in this case you needed to look at?
Again, objection, how and why is not relevant. What he obtained is relevant.
Your Honor,
Objection.
how and why?
Overruled.
Thank you.
Well, I was focused on the social media of the parties that were of interest, either persons of interest, maybe witnesses, just as much. Whenever a name came up, I endeavored to find their social media, regardless of whether or not I actually thought that they were directly involved in the homicide. Perhaps there'd be something on their social media that would shed some light or illuminate something for me.
Now, did you ever look at the social media of a Quindarius Zachary?
I do, yes. I recall looking at his social media, yes.
Do you recall what his handle or handles were for various social media platforms?
Not off the top of my head, no.
Would looking at your report refresh your memory?
Yes.
Would you please look at your report?
Yes, and that's what's on the laptop in front of me, incidentally.
Okay,
I just have it so I can do word searches.
all right,
I mean, I know he went by the moniker Little D.
okay.
Yeah, I mean, unless you can point me to it, I don't know that I actually put like a screenshot or an image from Mr. Zachary's, any of his social media in my report.
Okay. I'm going to show you what has been marked as State's Exhibit 360 Yankee. Speaking of social media, 360 Yankee through 363 Yankee. At what point did you begin looking for social media photos related to Javaris Bradford?
That would have been, again, I don't know the specific date.
And
But
I don't mean the date. I mean, what was your attention turned to Javaris Bradford?
Mr. Bradford caught my interest after, because as I said, I already had phone records belonging to various parties. These were phone records that I think were primarily, if not exclusively, obtained by investigator Tyrone Dennis. He caught my interest after I saw his number and his number being 404-957-8008. His number I found in the phone records of Quindarius Zachary, Demise McMullen, Kenneth Copeland, and Calvin Treadwell, meaning that I called detail records for those 4 people. And as I looked through them, I found that in close temporal proximity to the homicide, or maybe not, when I say close temporal proximity, it could be like a day or two within a day or two of the homicide, not necessarily within like 10 minutes. But I saw that he was that number, and I didn't know whose number it was when I first saw it, was a common number between them. In addition to that, when I ran it through the Fulton County Jail inmate call database, I found that another person who was an associate of those 4 people called that number, and that'd be Martinez Arnold. Martinez Arnold, aka Duke, was an inmate at the Fulton County Jail. So I ran 404-957-8008, which are 404-957-8008 through the Fulton County Jail's inmate call database. And I found 2 calls, I believe, that were placed from Martinez Arnold on the night of the homicide. And I think the first one was at 8:18 p.m., which was an hour after the murder. And so after I listened to those calls, I wanted to know a little bit more about Mr. Javaris Bradford. And as part of that process, I found his Instagram page.
I'm going to show you now what has been marked as State's Exhibit 360 and provided to the defense. State's Exhibit 360 Yankee.
I'm sorry, can I, before you,
Absolutely. 361 Yankee and 362 Yankee.
I feel like I asked y'all to share exhibits that you were going to use with witnesses prior to using them with the witnesses. Is that not happening?
I believe that this has been shared for quite a while.
it is.
Okay.
We just want to make sure which ones you.
Additionally, I will show to you 363 Yankee and provide to anyone who would like to see 363 Yankee. Do you recognize what has been labeled 360 Yankee? Thank you. 361 Yankee, 362 Yankee, and 363 Yankee.
I recognize these, yes.
How do you recognize them?
These were, I found Mr. Bradford's Instagram page. The moniker that he went by on said Instagram page was that is spelled IM_living, LIVING_great. When I found a picture or a post being a picture, sometimes with text accompanying it, although on these 4 pictures, it doesn't appear that Mr. Bradford actually posted any text along with the pictures. So those pictures, I screenshotted them. And these were the screenshots that I actually took as I viewed Mr. Bradford's Instagram page, the content of which was visible to the public.
Okay. And are those fair and accurate representations of the pictures depicted on the pages that you were looking at for Mr. Bradford?
They are, yes, they're printouts of the digital images that I captured, yes.
The state tender State's Exhibit 360, 361, 362, and 363 Yankee.
Those are admitted.
Thank you. Now, looking at 360 Yankee, would you tell the jury what they're looking at in 360 Yankee and what relevance it had to what you did after you got these social media posts?
360 Yankee depicts Javaris Bradford standing behind a Pontiac Bonneville, a gray in color Pontiac Bonneville. And I want to make sure, I think it's a 2002 Pontiac Bonneville. I want to get that right, so I'm refreshing my recollection. But I'm pretty sure it's a 2002 Pontiac Bonneville. But at any rate, it's a gray in color Pontiac Bonneville. And the reason why that caught my interest is because There was actually several photos that I found that depicted him alongside a Pontiac Bonneville, and that caught my interest because it let me know that that was probably the car that he could be found in.
Why were you interested in a gray Pontiac Bonneville at the time that you saw these images on
Well-
Mr. Bradford's page?
Well, at the time I saw these images, I wasn't.
Okay.
I mean, not really.
What did you see or hear, without getting into what anyone said, that caused you to take interest in these photographs? If it was an interview, he does not have to say what that person said. It
All
doesn't
right.
cause.
Well, I can say this. I looked at the surveillance footage and I knew that there was some type of gray car or cars that were involved. So gray car in general would have caught my interest. And when I say surveillance footage, I'm referring to the surveillance footage from the cameras that were mounted on 330 McDaniel Street, that being the barber shop in the parking lot, which Donovan Thomas stood at the time that he was shot and killed. But then there was other surveillance footage from the Texaco station. And so and to be clear, just so we're clear as to how the process went, when I first found these images, I was kind of generally interested. I said, oh, a gray vehicle. Okay, a gray sedan. But then as I went back and I reviewed the surveillance footage from the Texaco station yet again, I became considerably more interested in these images because I saw a gray Pontiac Bonneville on that footage in close temporal proximity to the homicide. And because that Texaco station was in close spatial proximity to the barber shop, that particularly caught my interest.
When you said you went out and looked at the scene, were you able to determine and explain to the jury how far the Texaco that you were looking at, the images on the Texaco that you were looking at, were from the barber shop at 330 McDaniel Street?
It was about 100 yards.
And would that extend beyond the doors of this courtroom, out to the elevator, or something a little bit different?
It would be from about where I sit right now, probably about twice the distance from where I sit right now to the elevator. So from here to the elevator, double that.
All right. Now, when you were out there, was there a line of sight from where you were looking at on the Texaco footage to the front of 330 McDaniel Street?
Yes.
Did you notice whether there were any street lamps or any kind of lighting out there as well?
There were. I don't recall if they were working.
Okay. Now, after you looked at this Texaco surveillance footage, did you only look at around the time of the murder? In other words, if the murder happened at 7:22 p.m., did you only look at 7:22 p.m. and a few minutes before and a few minutes after?
No, I looked, I believe the footage from the Texaco that was of interest to me actually started at 6:38 p.m.
Would you tell the jury why or what it was about 6:38 p.m. that had any significance?
Objection as to relevance.
Your Honor, I would ask that.
Overruled. Go ahead.
And well, it was actually 6:41 p.m. having reviewed my notes, so it's about 3 minutes after that. Well, a 2002 Pontiac Bonneville that looked identical to the one that appeared on Mr. Bradford's Instagram page pulled up to a gas pump at that gas station.
All right. Do you remember which gas pump? In other words, was it the one furthest from 330 McDaniel, in the middle, or closest to 330 McDaniel?
It was an inside gas pump. It was in the bank of gas pumps that would have been closest to 330 McDaniel, but the vehicle wasn't utilizing the pump that would put it in the absolute closest spatial proximity to 330 McDaniel, if that makes sense.
It does. Now, when you say the vehicle wasn't using the pump, did the vehicle use either pump at that gas station for the entire time that the vehicle sat at the pump?
No, I don't believe that anybody ever gassed up the car, if that's what you're asking. I don't believe anybody, I mean, obviously the whole thing's on video, but I didn't, I do not remember anybody using the pump. I'm quite sure nobody actually fueled up the car while it was parked there at the pump.
At any time while you were looking at it, were you able to see individuals get out of or get into the Pontiac?
The
Your Honor,
front-
I would object as to the relevance, also as the best evidence. The video has been introduced.
Sustained.
Thank you.
Did, Your Honor,
Mm-hmm.
may I ask the witness whether or not, once he looked at it and saw whatever he saw,
Well, you can go ahead and
thank you.
ask that, and I'll see if it's.
Did you recognize any persons that got, and not from knowing them personally, but did you recognize any persons getting into or out of that Pontiac?
Objection as to relevance. The jury can make their own determination from the evidence that's already been admitted.
Sustained.
That you looked into further? Did you further look into anyone that you saw getting into or out of that Pontiac?
Well, yes.
Who, would you tell the jury about one person that you saw getting into and out of that Pontiac
I'm
that you
going to
looked further
object. Same
into?
question.
Ask the question again?
Would you tell the jury about one such person that you saw?
Sustained. Okay.
Did you see Diamante Kendrick getting out of the Pontiac?
I did.
Objection.
Your Honor, I'm
Sustained.
Move to strike, Your Honor.
It'll be stricken.
Who did you see getting out of the Pontiac?
I'm going to object. It's the same question.
Sustained.
Your Honor,
Yes.
would the court allow me to either approach and explain or allow the state to get information we believe will be made valuable to the jury at a later
I'm
time?
gonna
In other
object to
words,
that
would the
speaking
court
objection.
please conditionally allow
Approach.
us? watched the Pontiac at the gas station.
And incidentally, on looking at my report, it's a 2001 Pontiac Bonneville, according to my notes.
Thank you. After you saw that 2001 Pontiac Bonneville at the gas pump, did you see, can you tell the jury who it was you believed that you saw getting into and out of the vehicle based on the information you had at the time?
Well, there were multiple occupants of the vehicle, but I believe you're referring to Diamante Kendrick.
Okay. And what did you do once you saw Diamante Kendrick? Did you just see him or look at or observe him getting out of the vehicle, or did you do something else with that information?
Well, I wanted to speak with the other people that were with him in that Pontiac Bonneville and another vehicle that appeared in the frame at some point.
Okay. Now, when you say the people that were with him, were you ever able to make a decision about who you believed the people were that were with him in the Bonneville?
I eventually determined who they were and I spoke with them.
Okay. Did you only look at the inside or the outside rather of the Texaco station footage while you were reviewing this file to make decisions about the next step?
No, there was footage from the interior as well, the convenience store that was adjacent to the gas pumps.
Mhm.
I looked at that too.
And were you able to get closer up pictures of anyone inside that gas station?
Yes.
Now, did you find the person that you believed to be in that, getting out of that Bonneville, did you find that person's image on social media sites or in any other place that informed your next steps in the investigation?
Yes.
All right. So the person you believe to be Diamante Kendrick, what did you do once you believed it was Diamante Kendrick that you were looking at?
Well, I continued to watch the video, obviously, but I also, as I stated, endeavored to identify the other people. I mean, as you could probably determine by now, I thought there was an excellent chance that Javaris Bradford was also in the Bonneville.
Objection to his opinion.
All right.
Overruled.
Okay. And with respect to Javaris Bradford and Diamante Kendrick, was there anything about their actions while they were at
Objection
that
to
gas
leading
pump?
question.
Overruled.
Was there anything about their actions while they were at that gas pump? Specifically, you mentioned another vehicle.
Well, there were a couple of vehicles. At one, they were parked at that gas pump for a good long while, for over 30 minutes.
I don't believe the question calls for that. Go
So
ahead.
is it, oh, okay. You may continue. You said that
I'm sorry, what was the question now?
with respect to Mr. Bradford, you said that, and Mr. Kendrick, you said something about the length of time that they were at the gas station, at the gas pump.
Right, so they were there, the vehicle, the Bonneville was parked there from 6:41 PM to 7:17 PM.
Okay.
At 7:17 PM, it pulled off and it pulled off simultaneously with another vehicle, with whom one of the occupants of the Bonneville.
Who was it that you believed you saw the other vehicle that pulled off simultaneously?
Can object. Same objection as previously.
What did you say? Same objection as previous? Is that what you said?
Yes, in regards to his opinion of who he saw and best evidence also.
Your Honor, my question is, I hadn't finished it, but my question was, with respect to the vehicle that he saw driving off simultaneously, what informed the next step in his investigation in terms of what,
Okay, you may ask that question.
what about the interaction between the people in the Bonneville and the people in the vehicle that pulled off simultaneously with the Bonneville informed the next steps in your investigation?
Well, one of the occupants of the Bonneville ran up to the other vehicle and had a conversation for about 30 seconds with the driver. That said occupant then ran back to the Bonneville, boarded the driver's seat of the Bonneville, and the two cars left simultaneously. And this was within 5 minutes of the drive-by shooting next door at 330 McDaniel Street.
Okay. Did you do anything to determine what vehicle it was that drove off simultaneously with the Bonneville you believe to be occupied by Diamante Kendrick?
Yes, I just looked at the video. It was clear enough. I could tell what kind of vehicle it was.
All right. Did you do anything to obtain any records, registration, or anything else as it related to the vehicle that pulled off simultaneously with the Bonneville that you believe Mr. Diamante Kendrick occupied?
Yes, I sent a subpoena to various rental car companies to include Hertz.
All right. Why did you send a subpoena to various rental car companies?
Because as I reviewed the file, there was information contained therein that one of the parties of interest rented the vehicle that was utilized.
Okay. Were you able immediately to obtain any records of interest as it related to the vehicle that pulled off simultaneously with the Bonneville?
I did.
What was it that you were able to obtain?
A woman named Carolyn Fry worked for Hertz. Apparently their custodian of records emailed me documents that were responsive to my subpoena.
Okay. And what person did the documents that you received, what person did they relate to?
They related to Jeffrey Williams.
Okay. Once you got these documents from Ms. Fry, did you do anything to further look into them?
Well, I sought to obtain identify the location of the vehicle that was of interest to me, that being an Infiniti.
And what did you do to determine the location of that vehicle?
I believe I asked David White to just run the current owner information. It turned out it was owned by somebody in Mississippi. Rental car companies don't keep their cars for very long. It's since been sold.
Did you speak to people at Hertz to determine any interactions they may have had with the person who rented the vehicle?
I did not know.
Did your investigator or someone on your team?
Investigator White did, and I believe he was also with a detective or detectives from the Atlanta Police Department at the time.
Okay. Once you got information about the vehicle that pulled off simultaneously, would you tell the jury if any other vehicle furthered your investigation into this matter?
Well, there was, in addition to the vehicle, that Infiniti from Hertz, there was a 2009 Volkswagen CC that also pulled up near the 2001 Pontiac Bonneville, and a occupant of that vehicle exited the Volkswagen CC and boarded the Bonneville. So I was eventually able to determine who the two people in the Volkswagen CC were as
You
well.
believe them to be?
I,
Go ahead.
well, yes, who I believe them to be, yes.
And were you able to in any way confirm their identities?
Yes, because I talked to them.
Okay. Once you spoke to the people who were in the Volkswagen, and once you determined who rented the vehicle that pulled off simultaneously with the Bonneville, what step did you take to gain more information into or determining who was
Objection to
responsible?
the characterization of solving.
She rephrased.
You may answer.
Well, I tracked down those people that I first believed to be on the footage, and then I interviewed them.
Okay. Now, on scene at that gas station, did you ever see anyone that you believed to be Kenneth Copeland?
No,
Okay. And did you ever see, as it relates to either of those vehicles in that footage, anyone that you believe to be Kenneth Copeland?
no, I did not see anybody that I believed to be Kenneth Copeland.
Were you able to obtain and review phone records for Kenneth Copeland?
I did.
All right. And what number did you review the records for?
Well, I'm gonna have to, if I may, refresh my recollection on that.
Please do, and just let me know when you refresh your memory.
There we go. 678-278-5991.
Did you obtain phone records for anyone related to Kenneth Copeland in order to assist in your investigation? And I'll be specific. Did you ever obtain any information regarding either a Deshaun Quarterman or a Rontrez Brock?
Probably. I probably subpoenaed subscriber. I definitely know those names.
Mhm.
And I definitely remember identifying their phone numbers.
Okay.
And and if there's records in the file, then that means I sent a subpoena. I don't believe I got search warrants for those numbers. I don't think I had probable cause, but I was at least able to obtain, subscriber information and call detail reports.
Now, did you speak with anyone or did you learn of anyone by the name of Sammy Davis during your time looking into this case?
I did.
Now, was that person already named in the file that you received from Detective Thorpe?
No.
How was it that you learned of the name Sammy Davis in this investigation?
So I believe it was on September 26, 2016. I met with Mr. Donovan Thomas's mother.
With that, go ahead.
And
You can go ahead.
and she mentioned that
I'm going to object to it. Sorry, go ahead.
Sustained.
Did you get information from Donovan Thomas's mother that led you to Mr. Davis?
yes.
After speaking with Donovan Thomas's mother, did you see anything on the news media or television that was of interest to you?
There was some news footage.
The hearsay.
Avoid hearsay in your response, please. I don't know if he's going to say it that way or not. Go ahead.
You can go ahead and answer without saying
Yes.
what anyone said. What did you see? Did you see footage of people being interviewed after the murder of Donovan Thomas?
Yes.
All right. And were these people on scene the same night? Or was this information that you viewed from?
Objection to the leading question.
Sustained.
What time in relation to the murder were these people being interviewed? By time, I do mean date-wise. Was it months after, close in time, temporally?
As far as I know, after the murder that night.
That same night?
Yes.
Okay. And who was it that you were looking at in this interview? What was the name of the person, if you recall?
No, that I don't recall.
Okay. Was this person in any way able to give you information that led you to find Mr. Davis?
I never talked to this person.
Was the information that you saw on the television instructive in determining Mr. Davis as a person of interest?
I don't know. I don't think so. That's not how I identified who Mr. Davis was. The news footage isn't how I identified him.
How did you go about finding Mr. Davis?
Well, I knew enough about them that I could reference this public records, and I don't really recall exactly how I did it. I just remember that I knew enough about this person's life that I was able to look at public records and eventually figure out that get the name of Sammy Davis and the date of birth. And then I was able to find him and interview him, and he confirmed.
Hold on, don't say what he said. You were able to interview him?
Yes.
All right. Now, once you interviewed Mr. Davis, at that time, did you have other phone numbers that were of interest in your investigation?
There were many phone numbers that were of interest in my investigation.
Were there any that you used in your investigation more than others?
Well, yeah, I'm sure there were numbers that were more interesting to me than others. Yes.
Specifically, did you find a number or did you locate a number you believe to be associated with the demise McMullen?
I did.
What number was that?
Hold on, I'll have to refresh my memory on that. There we go. That number was 470.
Your Honor, I'm actually going to object to that testimony. Any information that he received from hearsay would be inadmissible. I object.
From what would be?
Hearsay.
Your Honor,
Sustained.
I'm actually asking not whether it was, I asked him whether or not he found a number that he believed to be associated with this person.
That would be hearsay, Your Honor.
It's not talking about what anyone else said. He hasn't even gotten into other things that he did to
To the extent
look
that he
into that number.
To the extent that he received that information from someone else, and to the extent that it's being offered for the truth of the matter asserted, specifically that that number belongs to a certain person, that would be hearsay.
It is big,
Sustained.
Your Honor. All right. Did you look into or get and observe and review phone records for a phone number 504-975-3904?
I did.
What about phone number 504-346-9596?
Yes.
And 404-957-8008 that you talked about previously, was that another number that assisted more than others in this investigation?
It did.
All right. Did you look at and review records for 678-542-3145?
Oh, yes.
And what about 470-262-2643?
Yes.
Now, were you able to review any other case files to get information that aided you in the investigation of the Donovan Thomas murder? In other words, were there other incidents that you looked into obtaining information from?
Yes.
What incidents were those?
There were several.
And confrontation clause.
I don't know whether that's going to be the case or not.
I'm not asking for anything that anyone said. I'm asking about other incidents that he
I
reviewed.
know what you're asking. I don't know how it's going to be answered. We need to avoid any confrontation clause violations or hearsay, but can't rule on that without.
Can you tell the jury the location of other incidents that you looked into?
Well, there were several.
Your Honor, I'm going to object. Course of conduct, irrelevant.
Your Honor, I believe,
You know what, let's take our morning break right now. Mr. Sprinkle, can you step out?
Yes.
So I'm unclear where you're trying to go with this, which is why I'm not sure if those are valid objections or not.
Your Honor, as it relates to the other incidents that DDA Sprinkle obtained information relevant to this investigation, there were several. And I think that the jury has heard evidence of many of them. And the information that he got from those other case files and how he used it in this particular case, we believe is very relevant.
What do you expect his answer to be? What other case files? The alleged retaliatory back and forth that the state's theory has led to this?
We-
Or what? I mean, I don't know.
So, no, and the state's theory is not that the back and forth, retaliatory back and forth.
Just
led to it.
answer what it is that you think that is going to be the other incidents.
Your Honor, the Dexter Montgomery incident, the Adele Drive incident, incidents that involve Mr. Copeland. And the information that he was able to obtain and how he used that information.
All right. And what are the objections?
All right. So the objection is relevance. The objection is that it explains his course of conduct, which is not necessary and not relevant. I think the predecessor court heard at length the information about Dexter Montgomery. Several witnesses were called, detectives, investigators, witnesses from the prison system. And so the jury has heard that evidence before. They have heard the evidence about the Adele Drive shooting, both from officers who have come before the court and testified about it, as well as individuals who were there at the location. They have heard from Mr. Copeland for a long time, and both videos of him, detectives testifying about him previously, officers testifying about him previously. All of this information has been put in front of this jury previously. There's no relevance to Mr. Sprinkle at this point saying, again, regurgitating all of those and saying why they were important to him or important to the investigation. What importance they have, ultimately, they can argue in closing, but the jury is already before the jury. And so if I did not say that this evidence would be cumulative, I'll add that as well. But for the most part, it is irrelevant, and his course of conduct and why he found it to be important is not relevant to this jury.
Your Honor, may I respond?
Go ahead.
To the extent that what DDA Sprinkle did and why he did it is irrelevant, we would ask that the court not allow the inquiry into why any other witness, officer, investigator did what they did as well. We believe that it allows the jury to assess what happened during this case, assess the motives, the reasons why steps were taken, and to rebut the inference that the defendants are attempting to cause the jury to draw, that somehow or another, anyone in this particular case was targeted.
All right, I'm overruling the relevance objection and the cumulative objection, so he can say, I also looked at XYZ file and then move on from there. And Mr. Sharp, what was your,
I was a little slow on the trigger, but I was also hoping to object to hearsay, and this is my concern. Ms. Love just said, I just want to ask about information he obtained about these other cases. And from my understanding of Mr. Sprinkle's report, he didn't firsthand work or make observations of anything. My understanding is he read police reports or perhaps like in the case of Quindarius Zachary, he was in the proffer session, but all that is hearsay.
He utilized information.
okay, so I mean, you need to be careful about how you ask the question. So if the question is, he already said I looked at other files. So what were those files? And then what did you do? Not what did you glean from those files or why did you care, but just the next step. Okay.
Yes, Your
All
Honor.
right. Anybody, let's take our restroom break for the day. For the morning. Won't make it be the only one of the day and come back here and get the jury back. Council, get in here. Can y'all approach, please? Thank you. Go ahead, Ms. Love.
Thank you, Your Honor.
Whoops.
Mr. Sprinkle, we talked earlier about the numbers that you obtained records for and that you reviewed records for during the course of your investigation. Can you tell the jury whether you were able to find the number 404-621-4090 of any interest to you?
404-621-4090.
Yes.
Let's see. Yes.
And did you compare that number, 401-621,
404.
I'm sorry, 404-621-4090 to any other numbers? Did you do an analysis of that number in communication with any other number?
Well, I did. I saw that number in the cell phone records for Kenneth Copeland.
All right. Now, did you look at the time or whether that number communicated with the number that you had for Kenneth Copeland, 678-278-5991?
Yes, I did.
And would you tell the jury what timeframes you saw that number communicating with 678-278-5991 that aided in your investigation?
Well, so it's 6:58 p.m. on the night of the murder, that being January 10th, 2015. That number 678-278-5991, the same being the number for Kenneth Copeland,
Mhm.
that number called 404-621-4090.
And what times around the relevant time frame that you were looking at regarding the murder of Donovan Thomas, what times did that number communicate with the number for Kenneth Copeland?
Well, the phone call was at let's see, there was a phone call at 6:20 p.m.
Mhm.
and another one at, excuse me, 404-621-4090 called Kenneth Copeland at 6:20 p.m. And then Mr. Copeland called that number at 6:58 p.m.
Did you find the number of times numbers communicated with one another?
You mean like the frequency, looking at toll records and how many times a certain number was in communication with the number that is the subject of the toll records?
Yes. Did you look at that?
So a common call analysis, I'm sure I did. I generally do that in order to glean some sort of insight as to the identity. It's particularly useful when you don't know the identity of the person utilizing a certain number. If, for example, you have a number and you see that there's one number in particular with whom they communicate, the holder of the number communicates the most, you may be able to glean some insight as to who that number belongs to.
And did you determine whether there was communication between 470-217-6080 and 504-975-3904 or 504-346-9596?
So the phone number 470-217-6080, I believe you're referring to Demise McMullen's number.
So without getting into who you believe the number belonged to, would you just answer the question regarding whether or not you saw any communication between that number and the 2 504 numbers that I just mentioned around the time of the murder?
Let's see, I'm refreshing my recollection right now. Yes,
How long before or after the murder? What is the closest time that you saw those two numbers communicating with each other during or around the time of the murder?
My recollection, having been refreshed, notably, what I remembered was that at 7:29 p.m. on the night of the murder, that
29?
yeah,
Okay.
7 minutes after the 911 call,
Uh-huh.
that number, that 470 number, called 504-975-3904.
Okay. Do you look at any other records in comparison with one another to aid in your investigation?
Yes, there were numerous phone records that I inspected during my investigation.
What records did you compare or look at in relation to one another that aided in this investigation, if you would give the numbers?
Well, let's see here. Are you just asking me which sets of phone records I examined?
More like, did you determine whether 404-629-7604 communicated with 678-278-5991, for instance, around the time of the murder?
7604. That number
Not
did.
saying who it is.
Okay. That number, the 404-629-7604, called 678-278-5991 at 6:27 p.m. on the night of the murder, that being January 10th, 2015.
And did those two numbers, did that 7604 number show up with any high or low degree of frequency in the 5991 records?
Yeah, from what I recall, it did. That was somebody I believed was a close associate of the holder of the 5991 record.
Say that again.
I believe that number you cited, the one that ends in 7604, is a close associate of the, at least I believed to be a close
Objection
associate.
to his belief.
Did you look at it as if it were, did you analyze that number as if it were a close associate?
Yes.
Now, I'm going to show you what has been marked as State's Exhibit 510, Yankee. And I'll leave a copy for whomever wants to review it here on the stand. And ask you if you recognize just, do you recognize the picture and the date?
I do.
Did you obtain that particular picture and posting during the course of your investigation into the murder of Donovan Thomas?
Yes.
Is that a fair and accurate depiction of the photograph, date, and caption that you observed?
Yes.
The state tender State's Exhibit 510 Yankee as evidence.
Admitted. Yes.
Permission to publish, Your Honor.
Okay.
Looking at State's Exhibit 510 Yankee on the screen, whose social media account did you observe this photograph, caption, and date to be on?
Shannon Jackson, who also is known as Shannon Stillwell.
All right. And what is the handle or social media handle of this account?
OG_Bool, spelled BOOL.
And are you able to tell the jury if we can zoom in a little bit so that it can be seen a little bit? The date and time of this posting?
January 10th, 2015 at 9:58 p.m.
And what is the caption?
Overlooking the city with a lot on my mind, followed by a series of, and when I say series, I mean 4 emojis that depict faces.
Now, at the time that you saw this, did you know where it was that this picture was taken from?
It's like the inside of the Sky House
That would be
condominium.
based upon hearsay, Your Honor, I would object.
Sustained.
Your Honor, statement of, I think there's an exception, and I would like to say it to the court without announcing it.
Come up.
I've been there before.
And based on, what you know about Sky House condominiums, are you able to tell the jury with respect to 510 why? Where it appears that that photograph was taken?
Your Honor, I'm going to object and ask for some additional clarification. Knowing where a location is versus where a window is, the two different things. I'd ask for further clarification.
Again, I don't know what he's gonna say. He says he's been there. Can you develop that further before he testifies as to the question, like develop that he has the foundation to testify to that?
Yes. And I'm showing you what has already been admitted as Defense Stillwell Exhibit 4-4. Would you look at Defense Stillwell Exhibit 4-4?
Okay.
Is the photograph in Defense Stillwell Exhibit 4-4 the same photograph that is in State's Exhibit 510 Yankee?
It is.
Is there a date on Defense Stillwell Exhibit 4-4?
Yes, it appears that there would have been, but, and I can tell because there's a little pop-out bubble that indicates that, there was, but anyway, there was tone, there wasn't enough toner in the printer.
The jury.
Sustained.
So, DA Sprinkle, when you pull social media records, and you look at the actual records, is there anything about the record that will show you the date that a posting was made?
Yes, so this Defense Exhibit 44 that you just handed me, so if you go to Instagram and you mouse over the information in a post that displays how old the post is, in this case,
It does what?
but for example, on Defense 44, it says 109W, with W standing for weeks. If you're actually at a computer and you stick your mouse cursor, position it over 109, a date will pop up. There will actually be the date when it was posted. Here I see a box immediately below 109W, except the box has nothing in it. So that looks to me like that would, if you were to screenshot it, take a picture of your screen digitally, while you're mousing over that, and I know this because I've done it many, many times, then you should see the date of the post. I know that because that's how I capture posts on Instagram. Here, I don't see that. I don't know if there wasn't enough toner in the printer or what's going on, but
I'm going to object. That's a speculation.
About the toner in the printer.
There's no foundation for him he's certainly not an expert on mousing over
Well,
a date. I would object that there's no foundation and that it calls for speculation.
do you want to, sustained at this point?
Is that a picture?
Well, Your Honor, I have an objection as well. Seeing as now a foundation's been laid, I'd ask the court to instruct the jury as to why that box is blank.
Overruled.
And, Your Honor, if I may ask for assistance from Mr. Kokomo, who, to display Defense Stillwell.
You'll come up here for a minute.
tell the jury what it is that informs your opinion as to where the location of the photo in State's Exhibit 510 and DS 44 are.
Just having reviewed other photos in the case A, and B, just having been to that building and and therefore knowing its general location and looking at the exterior, that is the outside of the window. It looks to be that particular building at 1080 West Peachtree Street.
Your Honors, may I now put upon this witness that question? And is there,
I would still object that there's not been sufficient foundation for that particular photograph and location.
and where is it that it appears that the photograph that is in the exhibit before you and DS 44 were taken?
The sky, somewhere within the Sky House condominiums at 1080 West Peachtree Street.
Mr. Kokomo, may I have your assistance in displaying DS 44? Now, DA Sprinkle, will you please tell the jury whether these two photographs, 510 Yankee from State's Exhibit 510 Yankee and Defense Stillwell 44 are captured from the same social media site?
They are, yes, they are. The names differ because you can change your Instagram name whenever you like, and depending on when you capture it, it'll just capture the name that the person goes by at that moment. But yeah, they're the same.
And what is the social media handle for Defense Stillwell Exhibit 44?
SB_ with the shit. All one word with no dots, dashes, or any other manner of punctuation in between the words with the shit.
How many social media sites have you reviewed and been able to hover over a photograph to determine the date that the photograph was posted?
Thousands.
And on Defense Stillwell Exhibit 44, are you able to make the determination that you made earlier to the jury based on those thousands of reviews of social media sites and pages regarding the date?
Well, yes. I mean, that box that appears where the date would normally be. Now, if that was superimposed into the image from some other means, I don't know. All I know is that when you mouse over the age, that's when navigating your mouse cursor over the age of the post, it will pop up in a little box. It will say the specific date that it was posted. I see such a little box on DS44. However, there is nothing in it.
Okay. I'm showing you now what has been labeled as State's Exhibit 524 Yankee. Do you recognize State's Exhibit 524 Yankee?
I do.
And how do you recognize State's Exhibit 524 Yankee?
This is a image from Twitter that I captured, where I utilized that method, in fact, where the Twitter's a little bit different. It doesn't just say like 3 weeks old. They actually put the date. And the date here is January 10th, 2015. And when I moused over it, the specific date or time on January 10th, 2015 popped up. Specific time on January 10th, 2015 popped up.
Your Honor, the state tender State's Exhibit 524 Yankee as evidence.
Can I see that? That's another.
Thank you. Now, before we publish State's Exhibit 524 Yankee, would you tell the jury who it is that is depicted in 510 Yankee and Defense Stillwell 44?
That's Shannon Stillwell, AKA Shannon Jackson.
Okay. So go ahead and publish 524 Yankee. It's coming. And while we are publishing that, would you tell the jury who is depicted in State's Exhibit 524 Yankee?
This would be Diamante Kendrick, AKA Yak, AKA Yak Gotti.
All right. And is that from the Twitter account or Twitter feed of defendant Diamante Kendrick?
It is.
And what is that handle?
Yak Gotti, and that's spelled YAKGOTTY, or excuse me, GOTTI _.
All right. Now, what is the date and time that photograph was posted?
January 10th, 2015 at 7:35 p.m.
And is there a caption to this photograph that is depicted in 524 Yankee?
All right, let's see that real quick. There is. Y'all ends know me, Santana voice. Hashtag maniac back. All one word, spelled MANIAC with no punctuation in between the maniac and the back.
And is the photograph or the posting on the screen what you just read to and described for the jury, if we could blow it up?
Yes, that's it.
And the black box at the top with the date and time in it, is that the one that you were describing?
Yes, it is.
Thank you. Were you also able to get the Twitter feed for a Quindarius Zachary?
I did. I found that as well.
I'm going to show you what has been marked as State's Exhibit 526 Yankee, consisting of 259 pages. And I'll ask you as I approach this part of that exhibit, if 526 Yankee is the Twitter feed that you obtained for Quindarius Zachary. If you could just look at it and compare it with what you have.
So I feel like I also asked everybody to have their witnesses review these kind of things beforehand, so they didn't need to do them on the stand. Okay, so if you previously reviewed this for your testimony, you don't need to do it again now.
Does
Okay.
526 Yankee appear to be the Twitter feed that you captured for Quindarius Zachary?
Yes, that I saved. Yes, it is.
All right. And is that a fair and accurate reflection of the Twitter feed that you captured and saved for Quindarius Zachary?
It is.
State tenders 526 Yankee. Is
We
that
would
correct?
object on a variety of grounds. Number one, that it is hearsay. Number two, that it violates the confrontation clause. And number three, that there's been no authentication that these are legitimate Twitter records.
Okay, well,
There's-
that's not anything that we can sort out in this instant.
if the court will
So
allow me, I have a
why
response.
don't we move on to something else for a little while and we'll deal with that over lunch as well.
Yes, Your Honor. Would the court allow me to,
No, we'll deal with it
Okay.
over lunch.
will do, Your Honor. Thank you. So DDA Sprinkle, when you reviewed the social media accounts for Quindarius Zachary, for Diamante Kendrick, for Shannon Stillwell, did you observe or did you review the social media accounts for any of the other persons in this courtroom today?
Yes.
Whose?
I believe,
And if you need to refresh your recollection, please do so.
okay, I believe Jeffrey Williams,
Okay.
I looked at his. Diamante Kendricks, we already discussed.
Okay.
Shannon Stillwell or Shannon Jackson.
Okay.
That's all I can remember for right now.
Have you reviewed the social media account for Rodelius Ryan for any reason at all?
Yeah, I believe I did. It wasn't with regard to this investigation. no.
It wasn't in regards to the Donovan Thomas investigation?
No.
Okay. Now, what information did you use from the social media accounts you just described to the jury that aided in your investigation?
Well, there was a lot of, I mean, there's photos and videos that depict certain things, and these things, for example, would be who people,
Were
it
you
wouldn't,
able to see any associations that?
Yes.
aided in your
Objection as to
investigation?
hearsay.
Overruled.
yeah, I mean, if I see a photo, and I'm not naming anybody specifically, but if I take a look at a photo on a social media page and I see that it depicts, say, 4 people, and they're all together and they appear cordial, then from that I can say, well, they at the very least were cordial in that instance. And if I see multiple photographs that show that, I say, well, it seems like that perhaps they're associates. And then from there, I can continue to
Objection
delve.
to the speculation.
Overruled.
And then from there, if possible, I'd get a search warrant. I'd be able to find communications. And if the communications concern some of these parties that appear together, then I would be able to glean a little bit more insight into their relationship.
Okay. And when gathering these social media pages and sites, are there phone numbers associated with them as well?
Yes.
Did you look at any particular locations of interest as it related to those phone numbers that you gathered during your investigation? Without saying what you did, but did you look at, for instance, places like the Green Store?
I did.
All right. And did you look at, for instance, places
Objection
like?
to the leading question.
Sustained.
Did you look at residents?
I did.
Did you look at other businesses?
Yes.
Did you look at restaurants?
Yes.
All right. Now, when you said that you have been to Sky House condominiums before, do you have to do anything to get inside?
I believe there was some sort of controlled access. To get inside, I don't remember. I think it was Investigator Marissa Viverito.
I'm going to show you, we're looking at a portion, page 153 of a report that you did. Refresh your recollection.
Sure. Oh, yes. I see.
without talking about what it is.
Okay, I see that, yes.
So was there any sort of controlled access for Sky House condominiums,
Well, there was a,
Midtown?
there was a call box.
Okay, and what does that call box, what do you have to do?
Well, you would call it in order to get access to the building. I just can't specifically remember if when I went there, I was required to do that. Given that I went there in my capacity as a government employee.
Okay,
But I know that I identified that there was a call box, the number for that call box, et cetera.
was it controlled access?
Yes.
All right. Did you also look at the phone records for a 404-823-8553? And I'll ask you to, if you need to refresh your memory, I'll show you page 155 of the report that you offered.
Mhm. Yes, I did. I looked at those.
And who was that number registered to?
Objection, hearsay.
I can ask additional foundational questions. How did you obtain those call information, those call logs? Did you get or subpoena the call records from the telephone company?
I had those records, and I believe I obtained them from another investigator.
Okay. Now, would you tell the jury whether, when you spoke of looking at other incidents, whether any of those other incidents involved a artist by the name of Lil Wayne?
Yes.
And what incident was that you looked at?
There was a instance.
Objection, that's going to call for hearsay.
Overruled.
You may answer.
There was an incident in 2015 in which that Lil Wayne, I believe his name is Wayne Carter,
Mhm.
when his tour bus, while traveling along the interstate, sustained ballistic damage from a firearm.
And did you obtain or look at any phone records provided by the lead detective in that case?
I did.
All right. What phone number was that?
That was the number that,
Just give me the digits.
Objection to hearsay.
For the,
The phone number involved? So it's
Yes.
the sustained. Okay.
Your Honor. It's not making an assertion, it's asking if you got a phone number, not who it belongs to.
You can ask a different question, but the phone number you asked, the question that you asked called for hearsay.
Did you identify any numbers of interest while looking at that investigation?
I did.
And what number was that?
That would be hearsay. Objection.
Sustained.
Were you able to review the records for the number that you found pertinent to your investigation?
I did.
And did you observe or review communications made in those records?
The logs of incoming and outgoing calls and text messages, yes.
What number did you review incoming and outgoing calls and text messages from as it relates to that
Objection.
investigation?
That would be hearsay.
Sustained.
did you review the records for 770, or did you see in any of the records that you reviewed for 504-975-3904, communication with a number, and if you need to look on your report, let me know, 770-881-1440?
I did.
Okay. Were you able to determine anything about whether that call picked up or didn't pick up?
Well, yeah, it appeared to me that the call was answered.
Okay.
Actually, I take that back. I don't know that. I can't tell that it was answered. No, it's not apparent to me that that call was answered. No, I could just see there was an incoming call.
Okay. I'm going to now show you what has been Did you ever have an occasion to speak with anyone by the name of Kenya Morton without saying anything that that person said?
I did.
And did you have an occasion to speak with anyone who answered to a nickname Bushi?
But yes, that's Kenya Morton.
Were you ever able to review any calls made from the Fulton County Jail to a Kenya Morton?
I did.
And who were those calls made from?
Diamante Kendrick.
Were you able to review calls from the Fulton County Jail that involved a defendant Williams, a person identifying themselves as defendant Williams' sister or Dolly?
Yes.
Okay. And who were you able, if you can recall, who were you able to review calls between Dolly that Dolly had
Objection, that's going to
conversations
be
with?
hearsay.
Sustained.
were there any particular PIN numbers associated with persons who communicated with Dolly?
Yeah, if it was Martinez Arnold.
Also be hearsay.
Sustained.
Did you capture those calls?
Yes. If you mean by capture, or if you mean did I save them and preserve them? Yes.
And did you bring to court with you recording discs that contain the data that you captured as it relates to phone calls and jail calls in this case?
I brought multiple discs
Okay.
that capture with the jail call recordings on them.
Okay. And which recordings did you bring to court with you that you captured?
Well, so the last time I was here, last week or the week before, there was calls to 404-957-8008.
Mhm.
And I believe you have those.
I-
'Cause,
mhm.
let's see, I also have calls to a 404-629-7604.
And these are calls from the Fulton County Jail to those numbers?
Yes, this would be a call or calls to the Fulton County Jail to 404-629-7604. 404-629-7604.
Okay.
I have calls associated with inmate Antonio Sledge.
And what number was,
Oh, those are those are just all calls that were either placed from his account or numbers that he called frequently.
okay,
I have calls, Shannon Jackson, AKA Shannon Stillwell, calls either placed from his account or numbers that he called frequently.
okay,
I have calls for Demekion Garlington, same thing, where they're the calls either placed from his account or numbers that he called frequently. Calls from Kenneth Copeland. These were actually placed from the federal facility, the federal jail in Clayton County. And well, it's not just Kenneth Copeland, it's other numbers that are of interest.
okay,
And I believe that's it,
okay.
apart from the ones that I already handed to you last time I was on.
And
the
are
stand.
those that you handed to me last time in front of you to your right above the exhibits? Right in front?
Oh, here we go. Yes, yes, there are two. There's the Spencer calls that Spencer Wright called from the Atlanta City Jail and calls to 404-957-8008.
Did you also have an occasion to review any information related to an aerial Bax?
I did.
Did you ever speak with Ariel Bax?
I did.
All right. And when did you speak with Ariel Bax?
That would be on, matter of fact, I have that right here as well. That, and I'm going to refer to the disc with the interview to refresh my recollection. That would be on August 31st, 2018.
Did you see any communication going back to cell phone records between a number 470-262-2643 and 504-975-3904? And if you would refer to page 91 of your report, if you need to refresh your memory.
The 2643 and what other number was that?
3904.
Yes, yes, I did.
Did you see communication between those two numbers?
Yes, I did.
Were there more than one calls exchanged between those numbers?
Yes.
Did you have in the file that you received from Detective Thorpe interviews, or were you aware of any interviews of anyone else that was conducted on the night or within hours of the Donovan Thomas murder besides Kenneth Copeland?
Yeah, the police spoke with multiple people that evening.
Just one second. Your Honor, at this time, I would like to reserve the opportunity to, after putting up a different witness, call this witness back to the stand. But at this time, this concludes this portion of the examination of this witness.
All right. Do any of the defendants want to cross-examine at this stage? All right, go ahead, Mr. Adams.
Mr. Sprinkle, good morning, sir.
Good morning, how are you?
Doing well, doing well. All right, as I understand it, and you and I have met before, is that true?
Yes.
All right. You are a deputy district attorney with the Fulton County District Attorney's Office.
I am.
You have been so employed, as you've indicated in your testimony, for since 2013. Does that sound about right?
2011.
2011. Okay. One of the things that you talked about initially, I think your testimony, perhaps when you were here last, was your specific role in regards to reviewing case files.
Yes.
Recall that. I heard you say, and you tell me if this is accurate, that sometimes when a file comes to you from an investigating agency, that it is not always, in your words, complete.
Yes.
And you testified, did you not, that it would be your job or your duty, your responsibility to do some additional work. That may not be the word you use. You may have said investigation. I'm not sure.
I understand. Yes. If it's not complete insofar as we don't believe that it would be appropriate to present it to a grand jury and subsequently a trial.
Right. Because of course, your interest as an assistant district attorney is to make sure that cases are properly put before the court or put before a jury. True?
Correct.
And in fact, when you, one of your duties as a district attorney is to make sure that there is sufficient evidence or appropriate evidence presented in a case that goes before a court, goes before a jury. Correct?
Yes.
All right. Because it is important to make sure that people who need to be prosecuted are prosecuted, right?
Yes.
It is important to make sure that people who should not be prosecuted are not prosecuted.
That's correct.
You do not want, and your duty, I believe, encompasses this, you do not want to have someone charged or arrested or their freedom taken for an offense that they did not commit. True?
Overruled.
Is that true?
That's true.
Okay. And so I want to talk to you about a number of things, but I want to start by asking if I'm correct that when you came into this case, in 2016,
Mm.
The case had already been with detectives Gaither, Dennis, and Thorpe, right?
That's correct. Those were the detectives that primarily were the ones that I knew of that had been working on it. Yes.
Work had already been done on the case as far as you knew.
Yes.
In fact, people had already been arrested in this case.
Yes.
And I'm talking specifically about Donovan Thomas's murder.
That's right.
All right. Because that's what you were looking at.
That's right.
And so you knew by the time that you came into this that there were 4 people who were sitting in the Fulton County Jail who had been charged by the detectives whose name we've just referenced with the murder of Donovan Thomas.
That's
You knew
correct.
that. Kenneth Copeland, Shannon Stillwell. Who else?
Antonio Sledge and Demiki and Garlington.
All right. Those people, as far as you knew when you picked up this file, had already been investigated by the detectives, true?
That's true.
And by the way, you had worked previously. I mean, you knew who detectives Gaither, Dennis, and Thorpe were. You know who they were.
Yeah, I knew who they were. Yes.
You'd worked with them previously,
I had.
right? And so you came into this with people arrested, believing that the work had been done properly to have these 4 folks in the Fulton County Jail, right?
Well, that was my hope.
Right, right. That turned out not to be the case, right?
Correct.
In fact, tell me if this is right. I think you testified to this, that there was the interview of this gentleman named Spencer Wright in, what was it, October the 19th of 2015?
That sounds right. Yes.
All right. And that interview-
2015. Did you say 2015?
2015.
Yes. Yes.
Okay. And that interview was done by Detective Thorpe, correct?
Correct.
And the next day, the 20th, is when Detective Thorpe went in front of a judge and got an arrest warrant for the 4 people whose names we've just mentioned.
Yes. Yes, that's correct.
Right. And those 4 people were arrested and put in jail as a result of the investigative work that had been done by those detectives whose names we've just referenced.
Well,
correct?
I would, when you say those detectives, I would not, Detectives Gaither and Dennis, I wouldn't group them into that. It was Detective Thorpe that was the affiant on the arrest warrants for the Mr. Sledge, Mr. Garlington, Mr. Copeland, and Mr. Jackson, aka Mr. Stillwell.
Right. So one person swore out the warrant. That was Detective Thorpe, right?
That's correct.
But you're certainly aware that over the course of the investigation from January of 2015 to the time that Thorpe went and took out that arrest warrant in October of 2015, that he had communication and collaboration with Detectives Dennis and Detective Gaither. You know that, right?
Well, he sat in on interviews
Mhm.
with them. Some of these interviews that we've discussed or I discussed on direct. So, yeah, and they work for the same agency. So yes, I would say yes.
Right. And looking at your, what you've termed, maybe we've termed the Sprinkle Report,
Mhm.
right, where you kind of reviewed this case, looking at that report, you know that there were times when, for example, Thorpe would go and consult with either Gaither or Dennis about a particular individual that they were investigating. True?
I don't, it would seem like it would seem that would be the common sense thing that would have happened. And I'm not trying to be difficult, but I don't know what kind of, I don't know what kind of conversations Detective Thorpe had with Detective Gaither and or Detective Dennis.
Okay, well, here's a for instance. You know that there were interviews of Kenneth Copeland where Thorpe, Gaither, and Dennis were all present. right?
Yes.
And in fact, what was it, 9-10 hours worth of interviews of Kenneth Copeland?
There was one interview that was over 9 hours long. So, and there were multiple interviews with him. So it was over 9 hours. It
Okay.
suffices to say.
Right, so getting back to my, the question I asked a little while ago, you certainly had information that these 3 detectives, Thorpe may have been the one who took out the warrant, right?
Yes.
But these 3 detectives were in contact and communication with each other in regards to Donovan Thomas's murder. You knew that.
Yes.
Right. And ultimately, what happened is that they arrested the wrong people, didn't they?
Vagueness and the word they.
Okay. Ultimately, the detective Thorpe with the Atlanta Police Department, after consulting or talking to Gaither and Dennis, took out for these 4 individuals, charged the wrong people with the murder of Donovan Thomas, correct?
To that question, Your Honor.
Sustained.
When you, one of the things that you did when you first began to kind of look into what had happened in this matter is that you realized, and you said this in your report, if I'm wrong, maybe I'm reading it wrong, you correct me, okay?
Okay.
But one of the things that you said in your report is that it seemed as though the arrest of these individuals, by the way, these folks were arrested. I mean, they weren't just like suspected. They were actually put in jail, right?
We got that.
Okay.
Go ahead and ask your question.
All right, get in there. You said that this was almost entirely based on the statement of Mr. Spencer Wright,
Yes.
right?
Yes.
Okay. And it turned out that Detective Thorpe or whoever else was involved did a ridiculously poor job of vetting or looking into Spencer Wright's statement. Isn't that true?
Well, there was surveillance video that Mr. Wright said he was a specific place, and there was video that would have showed whether or not he was there. That apparently was not inspected very closely prior to obtaining arrest warrants.
Right. Well, in terms of not investigated fully, Spencer Wright, Thorpe spoke to Spencer Wright on the 19th of October, right?
Yes.
Now, when you came into the case, one of the first things that you thought to do was to really examine the statement from Mr. Wright. Is that true?
Yes,
And you did so,
I did.
and you spoke to him.
I did.
One of the second or third things that you did, right, just using some common sense, was to go and look for video around the location where you thought Spencer Wright would have been, right?
That's right.
And you did that,
I did.
and you were able to find it,
I was.
and it was pretty easy.
It was.
Detective Thorpe, before arresting folks based on your words, almost entirely the statement of Spencer Wright, never took the time to even go look for video where Spencer Wright supposedly would have been, did he?
Well, that I don't know. You would have to ask Detective Thorpe that.
Well, did you? Did you ask Detective Thorpe that?
Oh. I'm sure I did.
Let me guess. The answer was that he had not done it, right?
I remember the answer he gave at the preliminary hearing about the video.
Okay. Well, let me ask you this. When you come into the case in 2016, was there any video that had been procured from that location
Which,
by Detective Thorpe? Where the bus stop, where Spencer Wright
Yes.
would have been?
yes,
Was there?
there was a video camera, and in the viewable area of that camera was the bus stop where Mr. Wright said that he was standing at the time of the homicide.
Right. Had anyone gotten that video?
Yes.
Who did?
It was yeah, the specific investigator was probably either Frederick Page or Teague, Jason Teague, but
Okay.
ultimately it wound up in the possession of Detective Thorpe.
Okay. Before these 4 individuals were arrested or after?
Before.
Okay. And so even having the videotape that you looked at
Mhm.
and that you made a determination was pivotal in the arrest or in the case, even having that information, Detective Thorpe still went ahead and swore out the warrant for the wrong people on October the 20th?
That's right.
You, so after you realized that Thorpe had not done what should have been done in the case, right? You went a little bit further and you got some recorded phone calls of Spencer Wright, true?
I did.
And you were able to listen to those calls. And I'm not asking what was said, but the contents of those calls, you were able to listen to those, right?
I did.
And those were also instrumental in convincing you that here we are in 2016, that the wrong decision had been made by by the detective, right?
That's correct.
Okay. And so would I be correct, sir, that you then, realizing as an assistant district attorney charged with the duties that we've just talked about, used all deliberate speed at that point and said, you know what? Detectives messed it up, got the wrong people in jail. We got to get them out of jail right now.
Yeah, well, I disclosed all of this to the defense attorneys at the time. I can't remember if well, Antonio Sledge got out of jail pretty quick because that case was just thrown out at the preliminary hearing. The other ones, I would have to review the record. I know that, well, I'll just leave it at that. I don't, if they were in jail, I don't know if it was just on this or other things. I just don't know.
Okay. Did you do, what do you call it down here in Fulton? Is it an NPGJ, not presented to the grand jury when you dismiss a case?
Yeah, it's a form. It's, I don't know what I don't remember what it basically says. We're not presenting the case. The evidence is not sufficient. We're not presenting. That is, the DA's office is not presenting the case to the grand jury at this time.
Okay. And so when you realized what had happened in this case, did you file such a form?
Well, so that would have been the elected DA at the time, Paul Howard, that would have authorized or maybe have even signed that himself. But Kenneth Copeland, well, no, I believe that was done with Kenneth Copeland.
When?
I don't recall the date.
Does 2017 sound about right?
Yes,
Okay.
it does. I don't that again. I don't recall the exact date, but that does sound about right. Mr. Sledge, his was thrown out like January of 2016, I believe, whenever the preliminary hearing was. And as far as Garlington and Stillwell, Mr. Jackson, aka Mr. Stillwell's, was never thrown out. And as for Mr. Garlington, I don't know. I don't know if there was an MPGJ filed on him or not. There should have been.
Okay. As you're reviewing the evidence in the case, and we've just talked about Spencer Wright and that information, you talked earlier and you were asked questions about this other video that you looked for. Remember that?
I did.
And you remember a little while ago you were asked questions about video from the Texaco gas station.
Yes.
Okay. You remember, and I think you testified that there was this video that you received or that you were able to review of vehicles at the Texaco gas station not far from the barbershop around the time that the incident occurred, right?
That's correct.
You talked earlier, if I'm right, about this Pontiac Bonneville, right?
That's correct.
You talked about other vehicles that you saw, correct?
Correct.
You talked about individuals that you saw there at the at that gas station, right?
That's correct.
You were asked by the prosecutor whether you saw Kenneth Copeland on any of those videos. Remember that question?
I do remember it.
Your answer was no,
That's right.
because you did not see Kenneth Copeland at that gas station, that Texaco, sometime around the time that the murder occurred, right?
That's correct.
Right. You weren't asked, so I'm gonna ask you whether you saw Jeffrey Williams on that video at the Texaco at around the time that the murder occurred. Did
Okay.
you?
No, I didn't see Jeffrey Williams on there. No,
And you looked at the entirety of the video, right?
I did.
I think I heard you say that on all, I don't know if you said all of them, a lot of the videos, you went back and you looked at them multiple times, right?
Mm-hmm.
So January 10th, 2015, somewhere between, let's say, 6-something and 6:15 and 7:30, the time that you looked at the Texaco, Jeffrey Williams is not on any video, getting out of any car, getting into any car at the Texaco down the street from the front barbershop. True?
That's true.
Okay. I heard you say that one of the things that interested you when you looked at that video at the Texaco is that you saw an Infiniti. You remember saying that?
Yes.
Okay. And you became interested in doing some additional research or investigation on that Infiniti vehicle. You remember that?
I do, but actually, I think that if we're talking about when I decided to do certain things, I may have actually conducted additional research on the Infiniti before it caught my attention on the Texaco footage. I can't remember the exact, but just to be precise, yeah, I mean, it was probably around that time, but yeah.
But one of the things that we know for a fact is that you determined that you wanted to get more information about this rental vehicle, right?
Yes, that's right.
And you did. You and or your investigator made contact with the folks at Hertz, right?
It started with me when I sent the subpoena to Hertz. And then after that, after receiving some documents from a woman named Carolyn Fry, then I asked David White to travel to the location where the vehicle was rented and speak with the staff at that location.
Okay. So let me ask you some very specific questions about any information that you gleaned about that rental vehicle. You testified earlier that one of the things you were able to determine is that the vehicle was rented in the name of Jeffrey Williams. Is that what you said?
Yes.
You were not able to determine who it was that actually rented the vehicle, just that it was in the name of Jeffrey Williams. Isn't that right?
It was in the name of Jeffrey Williams, his driver's license number and his signature. There's a signature as well.
Now, tell me the date that that vehicle was rented.
From what I remember, January 7th, 2015.
All right. So that would have been 3 days before January 10th of 2015, correct?
That's right.
All right. Now, tell me, if you can, who had possession of that vehicle on January the 8th of 2010?
2015?
What did I say, 2010? 2015, yes.
Yes. I don't know.
You don't know who had possession of that vehicle on January the 9th of 2015?
I do not know.
And you certainly don't know who had possession of the vehicle, no personal knowledge of who had possession of that vehicle on January the 10th, 2015.
If we're talking about actual possession, the
Actual
person,
possession.
then no, I do not know.
Okay. You never strike that. By the time you came into this case, that rental vehicle, I mean, it had been at this point, what, a year since the incident? We're talking January 2016 is when you're in this case?
Yes, I obtained the records from Hertz in 2016. It would have been over a year. It would been around April of 2016 when I obtained the records from Hertz.
Okay. Now, I want to ask you about some of the things you did not do. Okay.
Okay.
You referenced earlier there were a lot of numbers being phone numbers being kind of, I don't want to say thrown at you, but put in front of you in terms of you were able to get information on this phone number and that phone number, the frequency of communication. You remember those questions?
I do.
And you did in fact have the ability to procure phone records by way of either subpoena or search warrant or court order.
That's correct.
Okay. You were able to get a lot of different phone numbers on people that you thought or individuals you thought might have been of some interest in the case. Is that fair?
That's fair.
Okay. You also, when you get those, when you request those phone records, you have the ability to request cell site or cell tower information, correct?
That's correct.
Now, and I know you're not an expert, but you are familiar with utilizing, maybe with an expert, cell site and cell tower information to try and make a determination as to where someone might have, or where a phone might have been at a particular time. True?
Yeah, I'm pretty familiar with plotting cell phone records. I'm not like an FBI CAS team member or anything like that, but I can hold my own.
Right. So having listened to Kenneth Copeland's statements, and you did that, all right?
Mhm.
Having listened to his statements, one of the things that you would have wanted to do, I presume, I'm asking, is try and determine whether or not you could corroborate certain information in his statement. Is that about right?
That's about right.
He gave, like we said, at least one 9-hour statement, and he gave a lot of statements. There was a lot to listen to from Kenneth Copeland.
Yes.
And he gave information that you would have used to follow up in your investigation.
That's correct.
The name Demekian Garlington came up in your investigation. Is that right?
Yes.
There was this reference in listening to Kenneth Copeland's statements. There was this reference to a conversation, phone calls that he would have had with Garlington, right?
That's correct.
And it would have been some interest to you to figure out whether or not what Kenneth Copeland was saying, not just about that, but everything was corroboratable, was true.
Yes.
Right? Or whether Kenneth Copeland was lying to y'all, lying to the detectives, not y'all, because he had already been interviewed, right?
Right. That's right.
Because you considered him to be a pivotal witness in the case,
Yes.
right? And some of the things that he said, you would have considered to be pivotal things that you wanted to follow up on, right?
Yes.
And if you have a witness, just like Spencer Wright, for example, if you have a witness who you think has pivotal information, but that witness is proven to be a liar, that's something that you want to know in regards to the investigation, true?
That's true.
And one of the things you could have done in regards to Kenneth Copeland and any statements he said, phone calls he said he may have had with someone named Demekian Garlington, is you could have gotten Garlington's phone records to determine whether or not those communications took place, right?
That is correct.
And also where Mr. Garlington was to see whether that comports with what Kenneth Copeland said, right?
That is correct.
Now, you got Kenneth Copeland's information, his phone information, right?
I did.
You got his location. So you knew, or at least the phone, where that phone was at certain times on the night of January 10th, 2015, right?
Well, to be specific, what you see with tower data is the tower and the side of the tower that the phone
Sure.
utilized. That can be a pretty large area. In a city with a lot of cell phone towers everywhere, you get a little bit of a better idea, but I just want to make sure that we're clear that it's not the exact location of the phone.
Sure. Not the exact, can't pinpoint within feet or maybe not even within a block, but it was important enough to you to get that information on Kenneth Copeland, on the phone that you thought was being used by Kenneth Copeland, right?
Yes.
Now, you did reach out to get information on Garlington's phone, or what you thought was Garlington's phone, right?
There was a number that I thought may have been Garlington's number.
Sure.
And I believe I referenced that in my report. And correct me if I'm wrong, I believe it was maybe a Sprint number, or maybe I can't remember exactly. It wasn't in his name. I was never the short answer to your question is I was never able to get tower data for Demekian Garlington.
Well, it's not that you weren't able to get tower data. You requested the data for that phone number and specifically requested it without the tower usage logs. Isn't that right?
Yes. So there was a number that was in Kenneth Copeland's records, came back, I want to say to a female. Now, and I remember, and this is, I'm thinking, and unless there's something that can refresh my recollection, from what I remember, I couldn't prove. It's one thing to get call logs are very easy to get. You don't need probable cause for those. But to get location data, you need probable cause. And I remember, from what I recall, I didn't think that I had probable cause to get tower location data for this number. Usually I'll try to do something like there's a number of things. Like if I find a jail call to the number and I hear the voice that picks up, I say, oh, well, that's then there, that corroborates that number is in fact that person's number. Or if somebody cites it on their Instagram page and says, call me on this number, that's going to get me to probable cause that that's that number. But if it's just that well, it's in temporal proximity. And I think there was another issue with the retention period of the number. I don't, all I know is I didn't think I had probable cause. I never got probable cause to get the tower records for
Let's
that
work
number.
backwards a little bit, right?
Mhm.
Let's start with this. When you sent out the request for the records that you thought was a number to Demekian Garlington,
Yes.
you requested those records specifically without tower usage logs, right?
I did.
Okay. Now, you had previously requested records for Kenneth, what you thought was Kenneth Copeland's phone number with the tower usage logs, right?
I don't know that it was me that did that. It may have been investigator or Detective Dennis that did that.
Right. But one thing that you knew, I mean, you honed in on the fact that there was supposedly this call between Kenneth Copeland and Demekian Garlington, and they were supposed to be at a specific place on the night of January 10th, 2015. Isn't that right?
That's correct.
Right. And so you had listened to Kenneth Copeland's statements, and you knew from Copeland's statements that he made reference to Wade Garlington, who was an important witness to you, right?
It was.
All right. You knew that Copeland had made reference in his hours of statement about this conversation and the location of Garlington, who was an important witness. You knew that,
That's right.
right? And so you still didn't think that that was enough for you to go ahead and try to verify whether Kenneth Copeland was lying through his teeth or not by getting Garlington's tower usage logs.
I will say one other
Your
thing.
Your Honor, may we approach?
Yes.
All right, Mrs. Sprinkle, so I'll just ask the question just very simply. Bottom line is, I am correct when I say that that you requested the information on Mr. Garlington's phone, but you requested those without the tower usage logs. Is that true?
That's right.
Okay. Now, I want to ask you something about a picture that we looked at a little bit earlier. All right. Remember the picture that the state put up? I think it was States 510 and DS 44. You have those in front of you?
I do.
Do you mind if I step up and take a quick look at them? May I, Judge? All right. May I, Mr. Franklin?
There you go.
I wasn't clear earlier, so I want to see if I can clear this up. You've been to what's been termed the Sky House, right?
That's correct.
As in, you have been there to the building, right?
That's correct.
Have you been inside to the individual units in there?
I have not.
So you've not stood inside of the Sky House in front of a window and looked out the window to observe what the skyline that you can see or what the view is you can see from a particular window, right?
That's correct.
Okay. And so those pictures that you saw earlier, you've seen the pictures before, right?
I have.
But you have not stood in the vantage point of the person in that picture to be able to say, this is someone looking out the window of the Sky House.
That's right. I have not.
Now, although the bulk of the work that you did was in regards to the January 10, 2015 shooting of Donovan Thomas. Am I correct about that?
That is correct.
Okay. You were asked a couple of questions about some other matters. Specifically, you were asked some questions about this Lil Wayne tour bus shooting business. Is that right?
That's right.
Right. Would I be correct in saying that what you know about that is information that you received from Detective Raisi and any other detectives or investigators involved in the case?
Yes, Detective RAISSI, David Racy. He, last I heard, was with the ATF.
Okay. You spoke to him and you got some information from him, correct?
I did.
You were not intimately involved in any investigation of that portion at all. True?
That's true.
You were asked a question earlier though about a phone number.
I was.
The prosecutor asked you about a 770-881-1440 phone number. Remember that?
I do.
Okay. That is a phone number that you looked at while you were looking at this whole Lil Wayne tour bus business. True?
I don't know if that, I don't know if that number caught my attention because of the Lil Wayne tour bus
Okay.
incident.
Do you know who Clifford Harris is?
Yes.
T.I.?
Yeah.
Okay. That's his number, ain't it?
Yes, that's what I found. That I
Okay.
concluded, yes.
And if I heard you correctly, that's a phone call to that number that may have been picked up, may not have been picked up, but ultimately doesn't have any significance to you in regards to this investigation. True?
I mean, just that it was an incoming call at 7:30 p.m. on January 10th, 2015.
That's it.
That's right.
Okay. Oh, you know what? Let me jump back a little bit, if you don't mind, to the whole Sky House business. One of the things you asked was whether or not there is controlled access at the Sky House. You remember that question?
I do.
Your answer ultimately was yes, right?
That's correct.
But the truth is, you referenced that there was what you believe to be a call box at that location.
That's right. There was a call box, a number that I identified. I just can't recall. There's obviously going to be controlled access.
Why do you say obviously?
Well, I mean, to get into the individual units, and there was a call box for which I identified a number. I just don't recall where the controlled access point was. Like, do you need one to get into the parking garage? Do you need one to get into the building? I just don't remember. From my personally going out there, I just don't remember.
Sure, and that's really what I want you to testify to, your personal knowledge. The truth is, you don't have any recollection as to whether or not there's any particular way to get in a gate, or whether there is a gate that you have to get buzzed in or anything like that. You don't know that, do you?
That I don't remember. I don't know if it's like the building, the door to the lobby was open, and then from there, or you had to get buzzed up. I just don't remember.
Okay. So the truth is, in talking about the Sky House and the access to the Sky House, you're really not in a position to tell this jury that, yes, there's a controlled access and there's a certain way to get in there. You just don't know.
I just don't remember. Like I said, I'm sure I know that there was some sort of control. I just don't know if it started at like the lobby door or in the parking garage. I just don't know.
Okay. Okay. Do you recall, you had an opportunity to listen to statements by various individuals in this case. Now I'm going to hone in on Quindarius Zachary. You had a chance to listen to his statement?
I did.
Okay. And you're aware that Detective Dennis had a conversation with Quindarius Zachary, is that right?
He and I both, well, there were a couple of them. During one of them, he and I both did.
You sat in, right, on one, but that's not what I'm getting at. I'm asking whether or not you had an opportunity to listen to any statements between Mr. Zachary and Dennis prior to your involvement in the case.
Yes.
Okay. Judge, may I have one moment, please? All right, Mrs. Sprinkle. Give a second, I have a chance to gather some more stuff. All right. I want to ask you about phone calls.
Okay.
And specifically about phone records that you were able to examine. Now, you obtained records for numbers that you believe belong to Jeffrey Williams. Is that right? And I'm talking now, I want to hone in, right? I'm speaking specifically in January of 2015.
That's right.
Okay. You obtained numbers that you believe belong to Jeffrey Williams.
Yes.
Okay. You obviously, as we've discussed before, obtained numbers that you believe belong to Kenneth Copeland.
Yes. Well, Kenneth Copeland, I believe that was somebody else, but when you say you obtain, I'm speaking, what I'm saying is I reviewed records. So either I or a DA's office investigator obtained them, or some law enforcement investigator obtained them, or if I obtained them via subpoena, et cetera.
Sure. And I don't, and listen, feel free to correct me if I'm wrong. And when I'm saying you obtained, I'll tailor it. You had a chance to review.
Yes.
Okay. You had a chance to review phone records that you believe belong to, as we talked about before, Mr. Demikian Garlington. Is that right?
There were records for Demeke and Garlington. Yes, but they didn't cover the night of the murder. Yeah, yes, there was also, and I think we talked about this already, a number that I found in Mr. Copeland's phone records that I believe was Demeke and Garlington's, but I never got to probable cause.
So here's my question, right? Focusing now on Jeffrey Williams, the number you believe belonged to Jeffrey Williams
There were a few.
and Kenneth Copeland, all right?
Okay.
There are, and I'm talking now about the night of the murder, January 10, 2015. There are 0 calls. I mean, 0 as in nothing, none, zilch. 0 calls between Kenneth Copeland and Jeffrey Williams. Isn't that true?
That sounds correct to me. There's the phone records can be voluminous.
Mhm.
So I'm going off of, my memory from, I feel like I would have remembered something like that. I'm also refreshing my recollection by looking at my report from the excerpts I placed in the report. And and specifically, I included Kenneth Copeland's phone records, the relevant portion from the night of the murder. And matter of fact, I'm looking at it right now. Yes, there are no phone calls to Jeffrey Williams.
Okay. What about phone calls between Demeke and Garlington and Jeffrey Williams?
No, I don't believe so either. No,
0 phone calls.
that's right.
Wiretaps. Did you have the ability to seek any wiretaps in this case?
No. We certainly had the ability to seek it, but we never did.
Okay, and I'm talking specifically, and you said we, but I'm speaking specifically now about Jeffrey Williams. No wiretap of any phone. You never sought any wiretap of Jeffrey Williams' phone, did you?
No, we never did.
I want to, so we've talked about what you've done in regards to the Donovan Thomas matter. We've talked about this tour bus shooting thing that you didn't really have anything to do with. I do want to jump back and ask you a question on a name that you mentioned earlier. Sammy Davis.
Okay.
Okay. Sammy Davis was someone that you spoke to.
He was.
Okay. That was someone who was supposedly at the location or somewhere close to the location on the when the incident occurred. I'm talking about January 10, 2015, correct?
That is correct.
And you had a conversation with him in 2016.
I believe it was 2017.
2017. Without saying what that person said, actually strike that. One moment, please, Judge. You mentioned earlier, Mr. Sprinkle, Twitter records that you were able to, I guess it's called X now, but Twitter records you were able to retrieve in regards to individuals in this case, or that you looked at. True?
That is correct.
Did I hear you say that you reviewed Jeffrey Williams's Twitter records and Twitter history?
I was aware that Mr. Williams had a Twitter page. I don't recall how closely I examined his Twitter page, though.
Okay. So you would not be in a position to tell this jury that there's anything about his Twitter page that you reviewed in regards to January 10th of 2015?
Well, if I did, it's not something that made an imprint on me such that I remember it. So I would say no, there was nothing.
Right, and because you are charged with reviewing and making determinations about what you think is important or pivotal in the case, if there was something there, that would certainly stick out in your mind,
Yes,
and it does not.
that's right.
I may have one moment, Judge. I may be, give me one moment, please. Before I sit down, I do have something that I wanted to jump back to. Remember we talked a little while ago about Mr. Copeland giving a statement about a conversation between he and Garlington the night of the incident?
Yes.
Okay. You recall from listening to Copeland's statement that he references that the night of the incident, he's supposedly at McDonald's and he makes a phone call to Garlington, right?
Yeah, that's right.
And you recall from his statement that Copeland also says that he ended up in a vehicle with Garlington and McMullen. You remember that?
I do.
Okay. Now, looking back again at judging the veracity of the statements people give to you, specifically now Copeland, you were able to determine that at the time when Copeland says that he is in a car with Garlington, that Garlington's phone, or the phone you think is Garlington's phone, is actually calling Copeland's phone at that time. You remember that?
No, I'm not sure. You must be referencing Mr. Copeland's cell phone call data records, and there's a phone call at a specific time that somehow occurs at a time when I don't know. Is that what you're talking about?
That is. Let me see if I can break it down anymore. Copeland gives a statement saying that he spoke to Garlington on the night of the incident, right?
Yes.
Copeland gives a statement saying that at some point he's in a vehicle with Mr. Garlington and Mr. Demise McMullen. True?
That is correct.
All right. Looking at the phone records, right, at the time when Copeland says he is in a car with McMullen and Garlington, you actually see phone calls between Garlington's number and Copeland's number when they're supposedly in a car with each other, right?
Well, so first of all, what number are we talking? Would you like me to say which number I believe may have been Demeke and Garlington's?
Sure. Go ahead and tell me what number you're talking about.
It was 404-621-0102. That would have been pretty much the only number during that immediate aftermath of the homicide with which he was in contact. And there were routed calls. Well, I won't get into that, but I had some, what I believe to be limited tower location data for that 404-621-0102. But the calls, there was an inbound call where that Naisha, 404-621-0102 rather, 621-0102 called Kenneth Copeland at 7:51 p.m. and 36 seconds on January 10th, 2015.
Right.
Now, you'll see, now again, if in fact that was Mr. Garlington's number, there were some routed calls that were but a routed call is not necessarily a communication between the two numbers. It could be an attempted call that wasn't completed. So, but as you would have to ask Mr. Copeland, about those phone calls and where he was, and if Mr. Garlington was actually in the car with him, or he was inside, the convenience store or the McDonald's or wherever it was they said they were. I don't know. I just don't know.
Well, okay. Let me ask you if you know this. All right. Again, we agree that according to Copeland, McMullen and Garlington are in a car together, right?
That's what Mr. Copeland said. Yes.
Okay. And there is a phone call. Let's not talk about Copeland. Let's talk about Garlington and McMullen.
Mm-hmm.
There is a phone call between Garlington's phone. That's the one that you've referenced, the 0102, right?
That's right.
what you believe is Garlington's phone, right?
Is that yes?
And there is a phone call that connects between Garlington and McMullen's phone at the time when they're supposedly in the car together, according to Copeland.
That, again, I don't know where I know that they were in close temporal proximity, or spatial proximity, I should say, at the time of these, according to Mr. Copeland. As to whether they were actually in the immediate confined space and they hadn't parted ways temporarily and one is calling the other, I don't know. You would have to, again, I don't know if they were within 3 feet of each other at the time of these phone calls. All I know is that they were within 3 feet. They were very close to each other during this time period, at least temporarily, and if they were walking around a parking lot, I just don't know.
Safe to say that verifying anything that Mr. Copeland says is true proved to be a Herculean task for you, huh?
Well, I just tried to find things that were obviously inconsistent. Like, for example, with Spencer Wright, where I just looked at the video and I saw nobody was at the bus stop. I said, well, that's obviously a pretty big inconsistency in a statement. That's all I was trying to do with Kenneth Copeland. And as far as the phone records are concerned, I didn't see anything that was wildly inconsistent or that completely contradicted him at all.
Something you said earlier when we were talking about the phones, you said that you're not an expert, but you have pretty significant experience with kind of looking at cell tower locations and if not plotting, at least trying to make a determination, reading those records.
Yes.
To determine where a particular phone may have been at a particular time, right?
That's right.
And it's fair to say, again, without asking you for an engineering or technological type answer, that those records that you look at that give you the distance or location of a phone is not an exact science. It's within miles, right?
It could. Potentially, yeah. It could be. In a populated area with a lot of cell phone towers, it'd be very odd to use a tower that's miles away from you. That may be something more in a rural area that you might see. But one thing I will say is, no, it's not an exact science.
Yeah, and
particularly the records at issue here was just, from what I remember, it's just tower usage and sides of the tower.
Right.
Meaning you're using this tower and you're using the antenna pointing this way. That's a big area.
And of course, we're talking about the city of Atlanta, which is very populous.
Mm-hmm.
And we're also talking about things like a call bouncing off of one tower or being routed to another tower because of the traffic, the cell tower, the cell traffic at that time. And the bottom line is that, you could be if you're trying to pinpoint where one phone is at a particular time, you could be a block off, a mile off. It all depends.
Yes,
Sure.
That's true. Yeah.
Okay. All right. I think that's all I have.
We're going to break for lunch at this point, and let's see. Let's come back at 2. for the jury. We will be back well before then. The rest of us. All right, Mr. Spring, okay. I know that the defendant's lunches are here, and I'm going to propose that we take a short break for them to eat and for maybe us to eat, I don't know, but that we come, let me get a little bit of clarification. So I know that the state at about 11:40 this morning sent over what they want to have reconsidered. And I'm not quite clear exactly what, obviously either agreed or ruled out as redacted, and you want each of them to now be reconsidered. And I don't want to get into the substance. I'm just, is that, you sent like several different ones. Is that what it's going to be with regard to each of them?
Some of them, the court said it needed additional-
Foundation.
Yes.
Okay. All right. And so you think either for those, foundation has been laid, or we need to take that up now, and then for others, you want reconsideration. Is that right?
That's correct.
Okay. All right. Now I had held a ruling on Mr. Zachary's Twitter feed that was states 526. Are you intending to introduce that such that we would need to take up the various objections that I believe Mr. Adams made, or no?
The Twitter feed, I would be, yes.
Yes. Okay. So is that something that we've not looked at all before now?
What do you mean, Your Honor?
Quindarius Zachary's, I mean, it looked to be pretty thick. That's all of his Twitter posts
It is.
for a
and I-
certain amount of time.
It is.
Okay. And is that something that the defense has seen previously?
It's been served in discovery.
Okay.
We have not had a chance.
We haven't
to-
had like an evidentiary. Okay.
We've
so-
not, and if I may just add, we also were not put on notice. The court had requested that they give us the list of the witnesses and the exhibits that are expected to come in through those witnesses. That was not in the list of exhibits for Mrs. Sprinkle's testimony.
Okay. So I mean, this is a voluminous record. Is that fair?
It has 259 pages.
Okay, so I'd call that voluminous. So how are we supposed to just off the cuff deal with what may and may not be admissible in that?
Because I have a set and small number of specific ones that I intended to actually publish. I just wanted him to, I mean, I tendered the whole thing because he got it, but I can distill it down and abide by whatever the court's ruling is.
So could you share with us all of the, whatever parts you think actually you would like to have admitted and
Absolutely.
published?
Yes. There,
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for
Okay,
anything.
I
and
mean,
will-
let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right, thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation and he can.
he can authenticate these.
I believe that.
Okay,
we can-
maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
Of, if you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they scroll, if they look at the.
Do
that
you
they
remember?
have,
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can. I can.
Resending it would be great,
All
and
of
then
that.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier. Okay, so you will do that and be specific about what parts you want in. All right, Mr. Short, you had asked in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date, or?
Yes, I would very much appreciate the court giving
Okay.
that instruction.
And that was
because
states 44, I mean, not states, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check.
You-
I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will
may I-
that work? Yes, no?
Yes, that would be
Okay.
great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right, I would also, let's see. So we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The
Ye-
additional crime scene photos
Your Honor,
from Mr. Atkins.
I don't know if we'll get to that or not. When,
Okay.
when would that be coming in?
not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, it
next,
may not be
depending.
coming in at all.
Well,
but
if
you-
they are to come in, it would be in about 2 weeks from now.
Okay, and it was so like, you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are going to be crime scene photos of? And why, like what crime scenes and why? I know Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about the?
So at the you want to know the actual?
crime scenes.
Okay.
And then why did you have to add those witnesses back in?
Well, the why was when counsel for,
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
that was half of it. The other
Okay.
half was that they objected to any of the,
Chain of custody, I remember.
right.
Anything
Right.
beyond that?
Yes, so I'm pulling up the actual
Okay.
incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I
until-
understand.
Okay,
I'm
thank
going to get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
Well,
The-
one was 2014, one was 2015, one was 2019, as I understand it. Which was that?
That was 2014.
Okay.
And that was based on an objection about the Niben hits. And then there was the 807 Prior and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle
Where?
on the road. It was, the specific address was,
This is something there was just testimony about last week. Yes, no?
oh, yes, I'm sorry. I thought you. Yes. That was rhetorical.
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Adkins represented in his email, then why should they come in now?
Your Honor, so as it relates to the scene, we believe that it's relevant information that does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that
Well,
they have not
Mr.
been.
Adkins represented that they hadn't.
And I have
so-
no reason not to
Okay, so
believe.
you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put him in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Yeah, are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and you base it on Davis versus State, 307 Georgia 746 from 2020, and also Adkins v. State, 301 Georgia 153 from 2017, and the law that's set forth in those about conduct of an investigation and an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation, that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands. So I'm going to overrule your objection. You may have a continuing objection to that. All right. See y'all back at 1:20.
Just you to know, we speak with independent crime scene people, so the state just giving us this, these photographs, and then we have to review the evidence and go talk to the witnesses. It's a hassle for us.
So if she lets me know that these were originally provided, that's one thing, but if they were not, then they're not going to be coming in. All right. See y'all in 30 minutes. Okay. All right, so those are out unless we find out that they were in fact served. So if you find that out, then you can bring that back up to us, okay? All right. Okay, so then this Zachary transcription, that would come in through Detective Gaither, is that right?
You mean the Zachary?
The things that you're asking for reconsideration of, or whether you've established the foundation for, would those be introduced through Gaither?
Through the interview, yes.
Right, but Gaither's going to be the witness with whom you get the interview with, right? Okay, and she's what, next after Sprinkle? Okay. Who else is going to have questions for Mr. Sprinkle, if anybody?
15 minutes.
Okay, anybody else? 5 minutes? Okay, all right, and then brief redirect, maybe? Okay, so then I'll look at this Zachary document that Ms. Love shared. And so I assume I'm assuming if you've included it in this document that you think there is a basis on which it should come in now. Some of them I can tell it was a foundation issue before. Others, I would need you to briefly explain why you think the ruling should change. Okay, so if you wouldn't mind just starting us out.
All right, so the first one, Judge, is page 24, line 4 to 25, line 19. What was requested was the conversation regarding Philo, Philo and D. So Philo and D shooted them based on
Okay, I'm sorry. I don't mean to interrupt you, but we don't have that much time. You don't need to set out what it is because we all have the document in front of us. Just let me know, just cut straight to the chase of why it should now come in, either the foundation you established or why it should be reconsidered, okay?
Yes, Judge.
Thank you.
So, Judge, when we had the witness on the stand, he acted as if he did not believe specifically that this was If Gang. We have testimony that has now come in and testimony that we will get in later, establishing who it was that these people are and how they're relevant. Specifically, his belief that these people, Philo and D, were shooting at Summer right after Demekion got jumped. And his belief that these are If Gang members, and his providing that information to the police is relevant evidence of the gang itself and the enterprise and the nature of the enterprise, in as much as these are people that he deems rivals that there has been beef with. So given that we've actually already put in testimony about who was living at 1428 at Adele Avenue, and given that I believe more information will come out about who these people are, we would ask that the court allow us to include this portion in our in the interview, because the objection was hearsay about who did the shooting at Demekion at the club.
I'm so confused. Isn't it still hearsay?
No, Your Honor.
How is it not still
Well,
hearsay?
One, because he's telling investigators.
Based on what she told him.
Right. And his actions, in as much as he reacts and responds based on that, and these are rival gang members, the fact that he is reacting to actions taken by rival gang members go to prove one of the elements or more than one of the elements of the crimes on our indictment.
So you want in those lines that you set forth, which are hearsay. So I don't see how you have presented any kind of an exception
Be- It's,
that would
It's
let
not-
this portion in.
it's not offered. The fact that the truth of the matter is that Philo and Dee shot at Summer. I'm not saying that they shot at Summer. His belief that they shot at Summer is what is important. And the reaction, his, Mooktoonks, and the other people that he apprised police participated in this shooting, their actions as a result of their belief that these people shot at Summer is what is pertinent. So the effect that these words had on them and what it made them do is what is important. Whether Philo and Dee shot at them, in fact, is not what we're asserting and not what we're offering it to prove.
Okay, any defense response?
Specifically to this, this situation, I do agree with the court that this is hearsay, but just procedurally, Your Honor, regarding all of these matters, we previously litigated this. I remember when we litigated this, I said, if the state wants to get into some of these things, they're going to have to lay a foundation and outside the presence of the jury. And that was what was discussed. We were going to have to talk to him and see how he knows some of this
Right.
stuff. And no one did any of that.
Right.
And so now he's not on the stand. So we avoided all these issues. Now he's not on the stand anymore. And now the state wants to relitigate this and get into these issues, which I believe are rightfully have been ruled inadmissible. But beyond that, we don't have the ability to ask him those questions anymore.
Well, I assume for some of the foundational ones, Ms. Love must think that a foundation was laid, but I guess we'll get to that when we get to it. But she thinks that there's something about what he testified to that merits reconsideration. So, I mean, I'll listen to what that is.
Your Honor,
Yes.
1428 Adele Avenue is where the mother of these
Yeah.
two people live.
I remember.
And so in as much as they're shooting up
Uh-huh.
these people in his mother's house because he believes that these rival gang members shot at his girlfriend, we believe that there's an exception. He testified that he personally shot at these people. There are inconsistent statements that are further in, but as to this part, he testified that he shot at Adele Avenue.
Right. He
But
did.
because of what information he provided to the police at the time that he interviewed with them in August, and because of what information we have from witnesses regarding the fact that there are more than there's other people on scene shooting that he's not wanting to say, and his not giving that information on the stand should allow us to not only put this information specifically about who was shooting at Summer in for its effect on him, but subsequent statements that he makes that are inconsistent with and contradicts what he testified about on the stand. So
So are you now offering this as a prior inconsistent statement, or are you offering it as not hearsay, or what?
I don't believe it's hearsay. I do believe that it is a prior inconsistent statement. What he told the police as it was pointed out so many times while I confronted him with the facts, he said he didn't remember what he told them. He told them he lied. All of that makes what he told the police a prior inconsistent statement. So all of those apply. I believe that these statements also contradict some of what he testified about on the stand.
All right, I'm not going to reconsider my ruling on that first one. All right, this next one that's page 55, what is it that you want in on that? And why? I'm, again, just a little confused about what it is that you think has changed.
You mean page 48?
The next one you have is number 6, page 55, line 17 to page 57, line 7. I'm looking at the
I'm looking. at
bottom
it,
of
Judge.
first page of the document that you provided.
I have it, Judge. Page- So, Judge, what he says at line 17, after being asked, so y'all don't really fuck with each other, meaning YSL and If Gang. Mr. Zachary says they didn't really mess with each other, so it was already tension in the air. But until that boy Yak, that boy that hang with Thug, had gotten into it with MDC, and I had helped him fight in the club, he is saying that that is part of what spurred on this antagonism between the two groups. Later in this interview, he talks about how the Woody jump on January the 6th wasn't what precipitated the rivalry between the two groups, and that in fact it had started about a month earlier. And what he is saying here, Judge, actually explains part of the reason that there is this antagonism. We are disproving some of the facts that this witness testified to, and we are showing the contradiction between what he testified to and what he stated previously.
All right, I can't follow you.
And the court ruled that this was bad character evidence about Kendrick. And what we're arguing is that in testifying that he is actually coming to the aid of Kendrick in this fight with people from MDC, and in telling the police after being asked specifically what started it all, after he tells them there was tension in the air that started at this point, it goes to show the association and the nature of the association between two co-conspirators in the YSL enterprise. It also goes to explain part of what the jury is hearing evidence about in terms of this back and forth in these shootings. So the court had said it was bad character evidence. We don't believe it's bad character evidence that rises to the level that justifies its exclusion, considering the charges that Mr. Kendricks is facing. And we believe that it is relevant, contextual.
All right, so for this one, you just basically want a reconsideration. It's not based on anything he said or didn't say. It's just, Judge, we really, really want you to decide that differently. All right.
Because you
so-
said that,
Go ahead.
you said, I don't believe that you had ruled that entirely out. You said, that you conditioned that the state could point out that Zachary defends Kendrick, but didn't want it line by line. And I believe that line by line is important when looking at the entirety of what he's saying. He's talking about a rival gang member and how
Well, he's actually, according to him, not talking about a rival gang member. He asks, they're not, he basically says, no, they're not really if gang, they're just themselves.
no, he's,
Okay,
Judge,
yes.
he says right after that, talking about
All right, I'm not reconsidering. My ruling stays the same on that one. All right, this one about the next one that you label number 11. I assume it's the 3 sentences in red that you think now should come in. Is that right?
yes, Judge.
Okay, and what has changed such that you think that should now come in?
Carefully reviewing and listening to what he says in the interview and reviewing it based on what was argued in the hearing. Specifically,
I think it was ruled out because it was speculation.
actually, Judge, this, I argue, Your Honor, was based on, given everything that Mr. Zachary says in his interview, this would have been based on information that he knew as a result of the communications that he has with them. It's not, I don't think that it's speculation. I also think that it directly contradicts what he told the jury. I think it is a prior inconsistent statement. And given what he tried to present to the jury in the form of his testimony, I believe that it's admissible for those reasons.
All right, if you're going to say it directly contradicts what he told the jury, I mean, he testified for several days, I think, as well. So what specifically?
He said he lied to the police. He said that he was asked on cross-examination, I believe, about his belief with respect to who killed Donovan Thomas.
Mhm.
He also talked in the interview about his interactions with all of the people that he said talked to him about the murder. And the fact that he specifically talked to Shannon, Yak, and later, after they got back from Miami, Nard, about the murder. And specifically, he tells the police that he asks, or that Mr. Williams, he keeps trying to say that at one point, Mr. Williams, he was just trying to get out of trouble. But in the interview, he is continually trying to keep Mr. Williams himself from being in trouble. All of this, I think, he has a foundation, he has a basis for the knowledge that, and he keeps talking about the fact that when they go out with guns, for instance, when Woody got jumped in January, everyone ran out with guns. They were saying, let's make the money. At a later point, he makes a similar statement. So the actions of the people that he interacts with, his co-conspirators, are what let him know and what specifically informed him as to motivations, what he is able to observe. He talks about that.
You did not establish through his testimony that he has a basis for knowing that they wanted to do it themselves to get a name. So I'm not going to change my ruling on that.
Your Honor, if his testimony, his entire testimony was that I lied,
I'm not reconsidering. I mean, I have reconsidered and I'm not changing my mind. Let's move on to number 13.
just one second. So, Judge, this is actually him specifically talking about Nard telling him that Woody was going to fold. This is classic co-conspirator statements. Also, the court said we needed to establish that Zachary knows the why, and reading specifically what he said, he's going to tell on us. He asks what, and Nard says about the nut situation and him telling him that he believes that Woody won't fold. He doesn't just say that's why Thug stopped messing with him because he thought he was going to fold. He says that Thug didn't know afterwards. And he also says that he specifically says that Thug asked, why did they do it? And once they were made aware, Thug was made aware that allegedly Nut had said whoop and given the green light, he was seemingly okay with it. We believe that the interview itself gives context as to how he was able to speak on why and what he observed with respect to Jeffrey Williams and Kenneth Copeland.
Notes, or maybe the court's notes, what is all this previously ruled inadmissible and the state seeking to admit it, or is there a part of this that was, because there's no color coding? I just want to make sure I'm on the same page.
Unfortunately, I don't have a whole lot in the way of notes.
Well,
Does anybody?
I do, but my notes are only as good as the person that takes them. So, but I have that the part that's being kept out is that's why Thug stopped messing with him because he thought he was going to fold. That was the part that was coming out because, and it was out unless a foundation for his knowledge, Quindarius's knowledge of what Jeffrey thought.
Right, okay, that's my recollection.
Right.
It's just that bit, not the conversation beforehand.
Correct.
Yeah. So, Ms. Love, what has now established that he had a foundation for knowing why Thug stopped messing with him?
He talked about the number of times that he was at Defendant Williams' condo, the amount of time he spent around him. I think that anyone that goes to anybody's house visits as often as he testified that he did, and has known someone as long as he said that he has known Defendant Williams, has established a foundation for being able to testify that someone stopped messing with another person for a particular reason.
Okay, so that's insufficient, so that ruling stays the same as well. All right, next is number 15, and it's the two
Part of what
in green.
the two in green are what the court kept in. I don't, with respect to the part that the court kept out, it strikes me, given that Kelvin Treadwell is an alleged co-conspirator. He is not only alleged to have been someone that took the guns and the vehicle based on what Mr. Zachary told the police, away from the scene or away from, to secret it away from authorities. He's also the person that called Demise McMullen back to shoot at
All right,
Dexter.
the first part is about selling drugs.
So one of the portions of the reason for the conspiracy existing here in this case is that they sell drugs and narcotics to further their enterprise. The indictment, the language of the indictment, and other acts that we have shown specifically about the use of drugs, the sale of drugs, and how they, it is one of the.
Let's not make the same arguments that have already been ruled on. What is it about the testimony that we heard from Mr. Zachary that should change the ruling on this?
Well, Your Honor, I think that the court ruled that it was irrelevant, the discussion of Bentley selling drugs. And I think that the court said that it did not know whether Bentley sold drugs to the benefit or for the benefit of
Right.
YSL.
Yeah.
But I believe that the court has also heard evidence, and this was something that was not presented as an argument, that in the Dexter Montgomery shooting, when Walter Murphy went back, or when he was called along with Demise McMullen to come and defend Kelvin Treadwell or OG Bentley, that he came from the spot, that it was, they kept guns at the spot, at the trap spot, and that this was OG Bentley's spot. And given that we believe that this is just pertinent information, given everything else that Quindarius Zachary said in his interview to the police about Kelvin Treadwell, about the drugs.
I'm not going to change my ruling on that. And with regard to the second part of it is clearly still total speculation. That when we move on to
So,
what happened to the car.
It's only, and actually, Your Honor, I should have been clearer. It is only the portion about the guns, the drugs that Kelvin Treadwell sells that Mr. Zachary told the police about that we were trying to get in, not the part about whether or not Nard wrecked.
Okay, well, I was moving on to that part. So I'm not changing my ruling on the first part, and you
So-
didn't even want the second part. So, okay.
So, Your Honor, with respect to the court's rulings on all of these matters,
Mhm.
given the testimony that Quindarius Zachary gave, is it that when he said he doesn't remember, was a hostile witness to the state and gave pertinent, relevant information to help prove the state's case in the interview, is it that because he won't say that on the stand that the court is keeping this information out?
No, ma'am, it's for the reasons that the ruling was based on before. Let's move on to number 16. And what is it about this that now you think should come in, and why? All of it?
I don't, number 16, I think that the court kept that. So with respect to that, those first 5 lines,
Mhm.
the court only said that you wanted us to bring this up with you before we get into it. Getting in that, hold on just one second. Judge, I want to make sure that I'm clear. The fact that Treadwell was Thug's road manager, that's not part of what the court took out, correct?
In fairness, when we went through this, there's the main focus was the speculation about what Donovan Thomas's sister knew
Mm-hmm.
and her reactions, and then just kind of gossiping on that. He's Thug's road manager is in the transcript, line 85, page 85, line 22. It's just not it's has it as unintelligible.
Mm-hmm.
So in fairness, that particular part wasn't kept out, I don't think, for the same reasons as everything else in this
Right.
passage. However, I will say, going off my recollection, I don't believe that I believe that came up during the examination of Mr. Zachary, and I don't believe Mr. Zachary denied that. I thought he said he used to be Jeffrey's or Thug's road manager. So that's already come out. And
Is that the only sentence that you wanted in?
Out of this group, yes, given that the way that the court has ruled on the rest of them, I'm not even going to take time up arguing about any sentence other than that one in this group.
Okay, and didn't he admit that anyway?
Not to my recollection, he did not.
Did you ask him about it?
I think unless it was necessary that I continue doing what the court asked me to shorten, which was confront him with every single line in his interview, that his saying he didn't know he lied, he's high every time the state asked him a question, and the court found that at the time he was testifying that we had gotten out enough to play the entire interview. I believe that that situation hasn't changed. So I believe that this is information that contradicts and is a prior inconsistent statement to his trial testimony.
Well, he, much like Mr. Copeland said, some of it was true and some of it wasn't.
Your Honor, when I was going through, there were repeated objections. The court admonished the state to not belabor confronting him with every single
Mhm.
piece of information. The court reminded the state that he didn't remember anything when it came to us. His
Mhm.
memory returned with the defense.
Okay, I mean, that wasn't out to begin with, so. The next one, 19.
Yes. So on cross-examination, we had originally said, okay, this is out. On cross-examination, and since this hearing, defense has continually asserted and made efforts to show that Kenneth Copeland was the person that, in fact, did this murder, I believe. They even went so far as to ask Mr. Zachary about his belief as it relates to Kenneth Copeland in committing the murder. We think that given the doors that have been opened since this hearing and through Mr. Zachary's testimony, that Mr. Zachary's statements and what police believed and how and why police believe what they did are relevant and pertinent in this trial, that the pertinent information that the jury should be entitled to hear.
Your Honor, this line, my understanding and belief is that Investigator Dennis is the one saying this.
Mhm.
That's, and talking about how the streets had already convicted Woody and the rest. I have no idea what Investigator Dennis said during an interrogation when he's asserting facts or alleged facts would be admissible, his out-of-court statement.
It's not coming in. The fact that he might be saying that in an interview does not mean it's anything that was the actual official position of the investigation. The one that you number 20.
So, Your Honor, as it relates to Antrevia Smith and who shot up her house,
Yeah, it was hearsay before.
we're not asserting that Quindarius Zachary says they say Kel and them we're not asserting that Kel and them shot up the house. We actually believe that Kelvin Watts was in the house. So in as much as hearsay is statements out of court that are asserted for the truth of the matter being asserted, we're not offering it for the truth of what Quindarius Zachary says. He's trying, we believe, to take attention away from YSL by saying Kel, the rival gang, shot at Antrevia's house. We have evidence that Quindarius Zachary and Antonio Sledge made a video threatening Kelvin Watts after, and that Antrevia Smith gave that video to the police after her house was shot up. We have evidence that her back door was open, so there is circumstantial evidence from which the jury could infer that they were in fact there at the house. Given that we're not offering it for the truth of the matter asserted, and given the testimony that has come out, and given that Quindarius Zachary trying to protect members of YSL for something that the jury could reasonably infer that they actually did, we'd ask that the court allow us to put up that information in the interview.
All right, that's still out. I'm not changing my mind on that. So 21, it was, did you establish that Mr. Zachary was present?
Actually, Judge, what I think that we did not argue and the court did not have, was not made privy to, is the fact that Mr. Zachary said that I'm sorry, just one second. That Mr. Zachary said that they came back and said, we just shot up Lucci's mama's house. My understanding is that the court said that we needed to prove that Shannon was present when they said that, and that under those circumstances, it's admissible as an adoptive admission. But given that Mr. Zachary also said that Kenneth Copeland said to the other two people that he told police committed this shooting, let's ride, that the three of them came back and that they said, we just shot at Lucci's mama. All of this is co-conspirator hearsay that should be admissible against everyone in court.
Mm-hmm.
And Your Honor, if the court is really not going to grant reconsideration, but will summarily deny,
I'm not summarily denying anything, or we'd be done and we'd have the jury in here. I'm listening to what you have to say about everything.
this is a co-conspirator statement that proves elements in this of the offenses charged in this indictment. We'd ask that the court reconsider and allow the state to put in evidence that.
All right, so what did you establish that Mr. Stillwell was present when Copeland said, "Okay, we did it"?
I believe that circumstantially, the jury can infer based on what he actually says in the interview
Okay, so no, then the won't be changed either.
And Your Honor,
Yes, ma'am.
it's.
You can argue circumstantially anything, but this statement, this part of the statement's not going to come in. Number 25, what's different now that should be reconsidered?
There was, I think, a specific cross-examination question about Mr. Zachary's opinion regarding who did this and why. And I think, again, given what information has come out before the jury, Mr. Zachary has shown himself willing and wanting to protect the people he gave previous statements about. And I believe that this information is inconsistent with what he testified to at trial and should be allowed as a prior inconsistent statement.
Okay, but in terms of establishing a foundation that he had a basis to know that anybody did this because they wanted a name, that didn't get established, right?
Your Honor, I don't. Yeah. Your Honor, so is the court unwilling to consider what was said in the actual interview as
I already
establishing?
considered what was in the actual interview as establishing or not establishing, and I made my ruling. So if nothing in the testimony developed that foundation, then the ruling stays the same. So that would take care of number 29. And then, well, I'm sorry, 28, 25 and 29, which takes us to 30. I don't recall hearing anything that, can you offer anything that should change the ruling on that?
Considering he denied everything he told them previously, I don't believe I can.
And then what's 32?
Judge, I'm not asking for any more reconsideration. Thank you.
Okay. All right. Okay, let's get Mr. Sprinkle back and the jury out.
And Your Honor, also before the court does, I just want to make the court aware that we did make efforts to get this video extracted and not pixelated, and it's going to be pixelated unless it's played through evidence reviewer. So we will be having to play it through evidence reviewer. We were not able to get a way to play an evidence reviewer video cleanly and plainly without evidence reviewer itself. Thank you.
Thank you. All right, Mr. Chart, you had questions for Mr. Sprinkle? You can be seated.
Thank you, Your Honor. Oh, Your Honor,
Yes. Oh, yes, thank you. Ladies and gentlemen, so before we broke for lunch, there was some discussion with this witness about comparing defendant Stillwell Exhibit 44, which was a picture with a State's Exhibit 510, which was essentially the same picture. And there was a little box. And I just wanted to let y'all know that there was nothing in that box at the time it was introduced into evidence, because at that time it hadn't been established what the box meant or if what was in the box could come in or anything like that. So that's the reason that there was nothing in that box. There's not anything nefarious about that. Okay. All right. Just want to let y'all know that. Okay. Go ahead, Mr. Sharp. Thanks for the reminder.
Your Honor, permission to publish DS 44?
Yes, you may.
Actually, you know what, 510Y? Do you have 510Y? Okay, DS 44.
You may.
Your Honor, may I approach?
You may.
Okay, Mr. Sprinkle, I am handing you State's Exhibit 510Y and Defense Exhibit DS 44.
Okay.
Okay, we can agree that that is the same picture?
Yes, the photograph is the same. The stuff around the photograph, the frame and whatnot is different.
Okay, and that photo is also on the screen, correct?
Yes, the DS 44 is on the screen. That's correct.
Okay. Now, I want to get this right as far as what your testimony is. You've been to the exterior of the Sky House, correct?
Yeah, I've been outside the Sky House.
As part of this investigation or another investigation?
It was this investigation.
Okay. You've never been inside the Sky House or inside the units?
No, I've never been inside one of the units.
Okay. Is your testimony that this is a picture of Shannon Stillwell in the Sky House or not?
I believe that it is, though I've not been inside the Sky House. That was my recollection from everything I put together, that was him standing inside the condo at the Sky House that evening. But if you were to ask me, like, if I stood where he is standing in this picture, no. So I can't say with 100% certainty now.
Okay. Now, in States 510 Yankee, I believe it is, there's a date and time on that photo, correct? On that exhibit?
Yes.
Okay, what is the date and time?
January 10th, 2015 at 9:58 p.m.
2015 at 9:58 p.m. Okay. Now, that is the date where someone posted this photo with this caption on social media, correct?
That's correct.
That is not necessarily the time when this photo was taken.
That's correct.
In fact, do you know who took this photo?
Well, there was somebody who told me they took the photo. I showed them this photo and they told me they took it.
Okay.
It's written in my report, so if I'm wrong, please let me know, but I'm pretty sure I recall who told me that.
Okay. And were you able to determine when this photo was taken?
I can tell you, all I know is what the person told me.
Okay. You're not, and I don't want to elicit hearsay, but you're not, please keep that up, Mr. Kokomo. You're not telling the jury that this photo was taken on January 10th, 2015, are you?
I don't know when the photo was taken.
Okay. Well, you're familiar with the seasons here in Atlanta?
I am.
All right. Sunsets?
Yes, that's correct.
Okay, 9:58 p.m. on a January evening. You would agree that that photo does not depict what the Atlanta streets would look like at 9:58 p.m. on January 10th of 2015, does it?
No, it'd be dark out.
It would be dark out if that was in fact the time.
That's correct. Eastern Standard Time, it would be dark out.
Okay, so bottom line is, this is Shannon, but we do not know, we don't have any information to say when this photo was taken.
That's correct.
Okay.
Well, I was told when it was taken thereabouts.
That information, I understand that we're getting back in this hearsay. That information wasn't that it was taken that day, was it?
That's correct.
It was taken another day.
That's correct.
So this photo does not place Shannon Stillwell at the Sky House on January 10th, 2015, does it?
Maybe it does, maybe it doesn't. I don't know. I don't know. Like I said, I don't know when the picture was taken.
Your information is it wasn't taken on January 10th.
That's, well, it was posted on January 10th, but I don't, like I said, I know that's not, I don't know that it was taken on January 10th. If the person who told me something else said otherwise, then it wasn't, or was telling me the truth, then it wasn't.
Okay. Let's talk about, and you can take that down, Mr. Kokomo. You can take that. Thank you. You became involved in this case in January 2016, correct?
Around that time, it may have been a little bit before that, but that was when I really started getting
Okay.
involved.
And I've read your report. You reviewed certain work done by other individuals, correct?
I did.
Okay. Now, my question to you is, were you provided with Detective Thorpe's file,
I was.
his entire file?
Well, I have what he gave me. Was that everything in his file? I don't know. I'm sure I asked him for everything in his file. I hope that he gave me everything that he had.
Do you have his rough notes?
I don't know that I got, no, I don't think I did. If it's not so with me, everything that I receive would be digitized. So if it's not like, in other words, if I were to get something like rough notes, which if he were to just give them to me, which would be unusual, and I would remember something like that, I would have immediately scanned them anyway, and they'd be reduced to digital form. If they're not in the digital case file, then I don't have them.
How about Investigator Dennis and Investigator Gaither? Did they give you case files?
They gave me, I wouldn't go so far as to say well, I guess it depends on what you define as a case file. They gave me cell phone records that I asked for, various videos and cell phone data extractions. I remember meeting with Dennis in particular, at least, it would have been multiple times, but yeah, and just sitting at his computer and him just saving things like cell phone records and whatnot to like an external thumb drive. So when you ask me if they gave me case files, it'd be something like that. It would be like data that was pertinent, like cell phone records, that kind of thing. But as far as like a completed case file, I don't know if I received anything quite like that from them.
Did they give you police reports that they authored?
Yeah, I seem to remember they
Did
did.
they ever indicate to you that some of their police reports were missing? That the Atlanta Police Department had lost them?
No, I don't recall. I don't recall anything specifically about any police reports being deleted. But they don't type them on a typewriter. There should be a database. I've never heard of that. I don't know how they would just be deleted. There'd be an audit trail or something. So no, I don't recall anything like that. It's not to say that nothing about like that was said. I just don't remember it.
Right. There would be a trail, an audit trail for reports that are typed in, but then go missing, correct?
Well, yeah, you would think, right? Like I said, they don't type them on a typewriter. It's some sort of database. I mean, I guess maybe I'm speculating a bit, but it's just common sense.
Judge, I would object speculation if this witness can't
Same.
say.
Let's talk about these videos. when you received the case file, we had a surveillance video outside the barbershop
Uh-huh.
from various angles.
There were 2 angles, I believe, that were pertinent anyway.
I think it was 3, but I got you.
Okay.
And then video outside the Texaco.
Yes.
Okay. I'm going to ask the same question since you volunteered that Mr. Copeland is not on the Texaco video.
Mhm.
Do you see Mr. Shannon Stillwell on the video
No,
outside the Texaco?
you do not.
Okay. Now, as part of an investigation, leave you out of it. Part of investigation is to obtain surveillance video, correct?
Yes.
And now when you take over, you said January 2016. I'm saying take over. Maybe that's not the correct word. You became involved January 2016, correct?
That's correct.
All right. That's a year after this incident.
That's correct.
Okay. Is it fair to say that over a year's time, things can happen with surveillance video, the availability of surveillance video that would make it difficult for someone taking over a year later to uncover surveillance videos that had not been retrieved yet?
Oh, yeah, absolutely. Surveillance videos they're just stored on computers and eventually but they don't have infinite storage. So there's a retention period that's oftentimes very short. It can be 48 hours to 2 weeks, but a year, I wouldn't think that you'd be able to get surveillance video after a year from anywhere, unless the people that maintained the video just like preserved it on their own without the prompting of the government.
And in a situation like that, the expectation of obtaining pertinent surveillance video would be on the original investigators, not someone taking over a year later like yourself.
Yeah, I mean, maybe particularly back then. I mean, maybe now with all these private companies like Ring, maybe they retain their video a little bit longer, but like a gas station where they just have the storage mounted inside their facility on like a hard drive. Yeah, you're not getting video after a year unless, like I said, they took the initiative on their own to preserve it.
And these time limits they're known to law enforcement. You know about these time limits, right?
Oh yeah.
Okay, it's not a secret.
No.
Okay, and that's why it's important to obtain surveillance video quickly in an investigation.
Yes.
It's going to be pertinent. Okay, so Green Store. You know that is Mommy's Grocery on Glen Street, correct?
That sounds right. I'm familiar with the Green Store. I can't recall the specific address, but that sounds right to me.
A minute from the barbershop.
Okay. I don't know if it's
Sound about right?
I don't know if it's quite that close.
Okay. Question that I have, when you took over this case and reviewed the statements, you became aware that Kenneth Copeland placed himself at the Green Store, according to his rendition of events, at the approximate time of the shooting. correct?
Objection, Your Honor. Misstatement and for the
Can you
facts.
rephrase?
Kenneth Copeland placed himself, upon your review of the work that had already been done on this case, you became aware that Kenneth Copeland, in his statements to police, placed himself at the Green Store at the approximate time of the shooting.
Wait, placed himself at the Green Store again. I don't know, because the thing, he wouldn't have, during his statement, he didn't know the exact time the shooting occurred. So I don't know that he would be able to say that I was there when the shooting occurred.
I know, but you have reviewed surveillance, you've reviewed the times. And what I'm asking is, did Kenneth Copeland place himself at the Green Store, to your knowledge, at the approximate time of the shooting?
So if the 911 call was at 7:22 p.m., which I believe it was, from what I recall, Mr. Copeland's cell phone tower logs placed him in the area of the Green Store starting at about 7:26 p.m.
Okay. So within 4 minutes of the shooting, he's claiming he's at the Green Store.
I don't know if he claimed that. This is what I found in his cell phone records. I don't know if he was actually at the Green Store at that time.
Did you not listen to his statements that he gave?
I did.
His June 10th statement. Okay. let me just ask you this.
But I just don't know if it was that specific where he said, this time I was at the Green Store. This is based on my review of his cell phone records, trying to piece together his timeline outside of the interview.
In your review of the case file provided by Detective Thorpe, did you ever see any surveillance from the Green Store?
No,
Did you ever make any efforts to obtain surveillance from the Green Store?
no,
Okay. McDonald's on Cleveland Avenue. We'll ask the same question. In the case file provided by Investigator Thorpe, did that have surveillance from McDonald's on Cleveland Avenue?
it did not.
Okay, did his documentation ever document a reason why that wasn't included?
I don't recall. I believe I just don't know. I don't know why it wasn't
And
included.
As part of your investigation, albeit after a year,
Mhm.
did you ever obtain any video from McDonald's?
I didn't.
All right. One last thing. Do you have your report in front of you?
I do.
Okay. As part of your investigation, I think you testified, but let me ask you this. Your role with the DA's office, it seems since 2013, has kind of been a dual lawyer/investigator role, correct?
Yes.
Okay, you're not in standard courtrooms necessarily litigating cases. You're doing more investigations.
I do the preliminary hearings on the murders, but yeah, for the most part, I'm just investigating cases.
Okay. Now, as part of your role in this special role within the DA's office, have you obtained training about forensics and evidence collection and things of that nature?
That's a broad question. I've been to there. Yes, I have attended training and CLEs and that kind of thing. It may be a little bit more specifically.
You're familiar with gunshot residue?
Yes.
Okay. And one of the places gunshot residue can be looked for is someone's hands, correct?
Yes.
Okay. And hypothetically, if I were to hand or fire a firearm,
Objection, Your Honor. This is improper for this witness.
I think that's a foundational objection.
I'm going to ask him about the work he did in a second.
A hypothetical.
I'm just getting there. Okay, well, forget about the hypothetical. Can you test someone's hands for gunshot residue?
Yes.
Okay. And the time window for testing someone's hands for gunshot residue is
Objection,
very
Your Honor.
limited, correct?
Ob-
I don't.
Objection,
Foundational,
yes, there is a foundation objection. Thank you.
sustained.
Do you, as part of your job, do you seek out search warrants to obtain evidence in criminal cases?
Yes. Well, I draft them and review them with the DA's office investigators primarily, and then they seek them out as the affiants.
So much like a homicide detective, you're able to look at a scenario, decide what sort of testing you would like on a certain piece of evidence, and then have the investigators that work with you draft such applications for a search warrant.
Yes.
Okay? And certainly, as in this role where you're seeking evidence, you know about the rules of evidence collection and what can be collected and the timelines that it can be collected in?
Yes.
Okay. Your Honor, I'd move to, I submit that ADA Sprinkle is an expert in gunshot residue collection.
No, I don't think that's been established.
Okay. Did you seek gunshot residue testing in this case?
I certainly contemplated on one specific item, but that ultimately didn't work.
Well, you in fact drafted a search warrant.
I did, yeah.
Okay. So let's go back. Hands, there's a limited amount of time that you can search for gunshot residue,
Objection,
correct?
foundation.
You need to establish that he, if you can, whether he knows that.
Do you know about the timeframes general as they apply to the collection of gunshot residue off of different types of objects?
No, I don't know that it's static. I don't know if it's, the particulate matter that is expelled from a gunshot just dissolves after a certain amount of time. I don't think that's how it works.
Right, it remains. That's
And
what I'm understanding, is it remains.
unless there's some external force that removes it.
Like sweat or washing your
Ob-
hands or something like that.
Objection,
correct?
Your Honor, foundation.
Sustained.
Okay. The rules for those timeframes are different from hands to other objects. correct?
Objection, foundation.
Sustained.
On May 9th, 2016, well, you were following up on with Hertz Rental Car about the Infinity, correct?
It would have been around that period. I don't remember if that was the specific day, but that sounds about right.
Okay, and through investigation, you were able to determine the actual VIN number of the Infinity, correct?
Yeah, I believe it was just within the records that is Hertz sent us.
Okay, and on May 9th, 2016, you located that actual car, the Infinity, correct?
Not me personally, but investigator, well, maybe I figured out where it was. Somehow or another, we figured out it belonged to a private citizen in Mississippi.
Miss Cleveland, who lives in Como, Mississippi, correct?
Irma Cleveland, yes.
And you confirmed that the car, the physical car, was in fact in her driveway on her property, correct?
There's some law enforcement officer drove out there and photographed it.
Okay. And on May 31st, 2016, you would agree that is 1 year, 5 months after the Donovan Thomas shooting, approximately 1 year, 4 months?
Yes, that's about right.
Okay. After finding this Infinity in Mississippi, you drafted a warrant, a search warrant for a search of the Infinity, correct?
That's correct.
And in fact, in that search warrant that you had drafted, you were looking for two things in particular, correct?
I remember gunshot residue was one of them, I believe, and also some data from the computer system.
Right. You were interested in extracting the contents from the computer system of the vehicle, the Infinity.
That's correct.
And you were also interested in a search for gunshot residue from the inside of that Infinity, correct?
That's correct.
Okay. Did you specify what parts of the car that you were seeking to have searched for gunshot residue to have wiped?
Well, I don't have the draft in front of me, but I would imagine the headliner, the cloth that kind of
Okay.
that is affixed to the ceiling of the vehicle.
Why would you have chosen the headliner?
Just in my experience, that's traditionally what's analyzed for gunshot residue inside a vehicle.
It's made of cloth.
It is. Well, I usually, I guess now that you mention it, I don't know for a fact that the headliner in this particular vehicle was made of cloth.
And it also would be at the top of the vehicle where the particles are likely to shoot up when the gun is expelled, correct? Or when
That's
the gun is
correct.
expelled.
Mhm.
Okay.
Objection, Your Honor. Foundation, relevance. 403.
Sustained as to foundation.
Well, as drafter of the search warrant, you felt the place to look for gunshot residue was the headliner of the vehicle.
Yeah, I don't remember if that,
Asked and answered. And with
Well,
respect to
overruled
foundation
Because he didn't answer the last one because there was an
No.
objection.
and
You may
foundation.
answer that.
you thought the headliner was a good place to look?
Yeah, I don't know if I just, in the search warrant, I said only take out the headliner. It was probably broad enough to allow the law enforcement agents to be executing the search warrant broad latitude in the surfaces that they analyzed.
And you were interested in having this search for gunshot residue inside this vehicle done, even though 16 months had passed since January 10, 2015, correct?
That's correct.
No further questions. Thank you.
All right, are there any other defense counsel? Mr. Weinstein?
Good afternoon, DDA Sprinkle. How are you?
Very well. How are you?
I believe we met once before, but my name is Doug Weinstein. I represent Diamante Kendrick.
Okay.
It's good to see you again.
Good to see you too.
So you've had some testimony today about people's general location with respect to cell tower, excuse me, cell tower data that you collected, correct?
That's correct. That's correct.
And for a cell tower, you generally have, for example, in some towers, you know the tower and it might have 3 antennas, each of which, for example, have a 120-degree arc, correct?
Yeah, that's the general rule. Yeah.
And so when you're locating people, when you testify to that, you're testifying about their general location because of the antenna that it's hitting, correct?
That's correct.
But you don't know the actual location of that cell phone, or even if it's within that 120-degree arc, do you?
No, you don't know. Well, there's a good chance it's within that 120-degree arc, but the exact location within that arc, no.
When
No,
you say a good chance within that 120-degree arc, I mean, you went to Georgia Tech, right?
Yeah.
In the engineering school?
No, public policy.
So you never took, for example, fields and waves over in the EE department?
I took, no, I didn't.
Okay. And so, but you're not aware that electromagnetic signals bounce?
Well, I'm generally aware of that. Yeah.
Okay. Just like, you know, if you shoot a basketball up at a basket and it comes down from the backboard, doesn't mean the person shooting the basketball was behind the backboard, right?
Right.
Okay. So when you say that someone's located at a particular location, that's just because of where the antenna is, right?
That's right.
Okay. You also testified earlier, and stop me if I'm wrong, that you attempted to interview Mr. Copeland, correct?
Well, I desired to. He had an attorney, and ultimately, it just didn't happen. Like, there was no interest from that side in allowing for the interview.
You desired to interview Mr. Copeland.
Yes,
You reached out through his attorney, correct?
if I remember correctly. Well, yes, it definitely would have been through his attorney, and all I know is it just never happened. I can't recall exactly what the conversation was, but I do know it never happened.
Did his attorney say, yeah, Mr. Copeland would love to be interviewed. Let's
Objection,
make
Your
a
Honor.
date for that?
Sustained, he just said he didn't remember.
Okay. Let's jump to one more thing, then I'll be done. The gas station video from the Texaco, the one that's exterior to the gas station. How many times would you say you viewed that video?
Wow.
Roughly.
75 to 100 times.
And you saw someone that you believe to be my client, Diamante Kendrick, right?
Yes.
And you saw him in the Pontiac Bonneville, correct?
Yes,
And you saw the Pontiac Bonneville pull out of the gas station.
I did.
And Mr. Kendrick was in the Bonneville when it pulled out from the gas station, correct?
He was in the driver's seat.
Of the Bonneville.
Yes.
He was not in the Infinity, correct?
He was not.
Thank you.
Any other defense counsel have questions for this witness? No. Okay. Is there redirect?
Yes.
Okay, go ahead.
Good afternoon again.
Good afternoon.
You were asked on cross-examination by Mr. Adams whether or not you were able to, whether or not you saw communication between Demise McMullen and Kenneth Copeland.
Correct.
Paul,
Yes.
what was the number that you were able to obtain for Demise McMullen?
So the number for Demise McMullen was 470-217-6080.
And you were asked as well about efforts that you made to corroborate information that you were given during specific interviews. Do you recall?
I do.
I'm going to show you what has been marked as State's Exhibit 528 Yankee. And ask if you recognize 528 Yankee.
I do.
How?
This is a picture that I obtained from Justin Cobb's Instagram page that I screenshotted.
Okay. Why did you, let me ask you first, is 528 Yankee a fair and accurate copy of the screenshot that you got from Justin Cobb's Instagram page?
Well, yes, though it's cut off a little bit on the right, where the timestamp is, the last number of the timestamp, it just says 201. But I mean, I recognize that it's otherwise fair and accurate. It's just cropped a little bit on the right-hand side.
Your Honor, the state tender states 528 Yankee is evidence.
I would actually object to it if it's not in the facts.
If it's what?
I would actually object to it if it is not as he remembers it to be, if it's been altered or if it's not the same that he's viewed previously.
Okay, well, it is admitted, subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I'd also object to any hearsay that may be contained within that document.
I don't know if there, I don't know what the exhibit is. So is there? Is that an issue I need to take up?
I don't believe so, Judge. I mean, I can show the court in.
Okay.
And Mr. Sprinkle, I'm going to show you digital version of 528 Yankee and ask you, are you able to see the date on the digital version?
I am.
Your Honor, state. There's 528 Yankee and ask for place.
Okay, so are you gonna, it'll ultimately be, are you just gonna make a better copy and substitute? All right, that's fine, then it's admitted in full.
as we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And I mean, that would, for the traditionally that's what I would do with an Instagram page. It's just posted in public view.
And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment, and
Was it posted by the owner or user of the account?
That was
Yeah.
false speculation, not object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to? What
I would
handle
renew
the
my
number
objection,
is
also
next to?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay,
and Your Honor,
when we were up here at the bench,
so, Your Honor, I'll ask additional questions that I think will,
sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, may we excuse the witness?
Yeah. Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so
Your Honor-
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at the document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge, the
Can somebody put the document up? I'm listening.
yes, yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with, where's the phone? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I
We-
said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or exhibit will prove or show that this is Justin Cobb's phone number.
You're
It
asking him that? And
No,
asking
Your
him to
Honor,
testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The
Is
entire
phone number with the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I
Right.
asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
that.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse
I
here.
asked,
It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm
I
asking
mean, I
for one.
can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court. And I think it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said from opening statement is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor,
would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
Yes, it's renewed.
Thank you.
Yes. Thank you. Ladies and gentlemen, upon further discussion, that last exhibit, which is State's Exhibit 528Y, is excluded from evidence. And so that means that y'all need to disregard it entirely in your thoughts and in your deliberation in this case. And as well, you need to disregard any testimony that might have been given about that particular exhibit. All right, go ahead, Ms. Love.
Thank you, Judge. DDA Sprinkle, you were asked on cross-examination about whether you attempted to determine whether Kenneth Copeland, in the words of Mr. Adams, lied when talking to the police. Do you recall that question?
Yes, generally, he asked me something about whether I endeavored to detect that or figure it out.
Did you make any steps to determine or to corroborate the information you gained from Kenneth Copeland?
I did.
Would you tell the jury what steps you took to corroborate information that you gained from Kenneth Copeland?
Well, there was a number of things that I did. I, in particular, looked at all the cell phone records. Like, for example, so I looked at the call detail records, the times that people were called or made calls, the parties to those calls, and also the towers that the handsets utilized by those calls. And as I've testified previously, you can tell somebody's general location based on the tower and the sector of the tower, the antenna of the tower that their handset utilizes to facilitate the call. And also, you can, in knowing who somebody is communicating with at a given time, that can tell you a little something as well. And so when I compared Mr. Copeland's statements to my analysis of the cell phone records, I tried to the best of my ability to corroborate as much of his statement as I could by analyzing all of that.
You were also asked on cross-examination the power went out over here. On all of the screens.
On what? I can't see any of the screens, so
They're black.
the monitors themselves are out. Okay, well, do we need them right now? Do we need them right now?
No, not at this precise moment, no.
So in terms of, is this one on? No. No? Okay. do we have our backup thing? It does sound like something went silent too, so.
Just to be clear, Your Honor, it's not the monitors that have lost power, it's whatever's feeding the monitors.
Okay. Well, we got the sound fixed, and so now we're gonna have issues with the video, the site. Yeah, I think maybe a breaker got thrown because it sounds like maybe the AC went out, which would make some people happy, I think. All right. I mean, if it's gonna be a few minutes before you get to the next exhibit, you can just go ahead with the testimony, and Ms. Pursfield will see what she can do about getting some sort of monitor back up.
Yes, thank you, Judge. DDA Sprinkle, did you utilize statements from other witnesses to corroborate information you obtained from Kenneth Copeland's interview?
I did.
Citation clause.
Not just from that, so overruled.
You were asked on cross-examination whether you obtained a wiretap for Defendant Williams' phone. Do you remember that?
Yes.
As it relates to the Donovan Thomas murder, would it be something you would expect to be able to get a wiretap for a year and a half later?
On the grounds of speculation.
Overruled.
As it relates to the Donovan Thomas murder?
So wiretaps are for evidence of things that are going to be talked about in the future. I'm trying to think. I don't believe I've ever obtained a wiretap to investigate a crime that happened in the past, solely to investigate a crime that happened in the past. That's not to say you couldn't. I have heard of such things, but I've not personally done it, and I did not do it in this case.
You were also asked on cross-examination about the photographs that depicted, or the social media postings that depicted Defendant Stillwell. Do you recall that?
Yes.
And did you testify that you obtained information about the photograph from a person you spoke to?
Yes. Yes. Apart from what was just, available and in the public internet form, that being the website from which I obtained them. Yes, I did. I spoke with someone about the photograph.
Okay. Mr. Adams asked you about Detective Thorpe consulting with Detective Gaither and Detective Dennis. Do you recall that?
I do.
Do you have any knowledge of whether Detective Gaither or Detective Dennis were consulted with before warrants were taken out by Detective Thorpe? In other words, did he seek their permission to take out the warrants?
No.
Do you have
No.
any knowledge about that?
No, I don't believe he did. No.
You were also asked on cross-examination by Mr. Adams about the dismissals and the NPGJ for certain people that warrants were initially taken out for the murder of Donovan Thomas. Do you remember that?
I do.
Were the dismissals of those warrants in any way based on the additional investigation that you did with your investigator, David White, into the murder of Donovan Thomas?
Well, no, not the one with Sledge. That was the Mr. Antonio Sledge. That was the preliminary hearing judge that threw that one out.
Mhm.
So,
Did you,
Hang on. All right, I don't know if your mic's on at all, but
I'm sorry, it was non-responsive and it was testimony about other court proceedings, which I believe is inappropriate and hearsay.
overruled.
did your investigation into the murder of Donovan Thomas lead you to present MPGJs for people who had been arrested for his murder?
well, yes, for the people that for which we didn't, the people that we didn't prosecute for the murder, yes.
Mr. Adams asked you specifically about corroborating the information you gained from Kenneth Copeland's interview. And specifically, he asked you about phone calls with Demikian Garlington. Do you remember that?
Yes.
Are you able to tell the jury what information Kenneth Copeland provided you that you were able to corroborate?
Well, well,
Okay, I think your mic's still out, but sustained.
You were asked on cross-examination by Mr. Shart whether Kenneth Copeland said he was at the Green Store at the time of the murder. Do you recall that?
I do.
When you are looking at cellular location information for cell phones, do you look at a static point in time to determine what a person's handset is doing? In other words, do you only look at the time of the incident in question, or is the time leading up to it and the time after it also relevant?
Well, yes, the times before, during, and after the homicide, it can absolutely be relevant.
Was there any point during your investigation where Kenneth Copeland said, "I was at the Green Store at the time of Donovan Thomas's murder"?
I don't remember that. I don't have every single thing that he said during his, particularly the 9-hour statement, committed to memory, but I don't recall him saying that, being even cognizant as to saying that he knew exactly where he was at the time that Donovan Thomas suffered his fatal gunshot wounds.
As it relates to what Kenneth Copeland did tell you about his whereabouts on the day of Donovan Thomas's murder, were you able to get information as it relates to any significant others in Kenneth Copeland's life about where he was on the day of the murder?
Well, so to be clear, I never spoke with Kenneth Copeland, but from the statements that he provided, yes, I believe so. I definitely, because he would reference people that he knew, I sought to identify, for example, phone numbers for those people, because again, that would go to my corroborating his statement based on, among other things, his phone logs.
Okay. When you testified on cross-examination that you were looking at big things for inconsistencies, what did you mean by that?
Well, so, a big inconsistency would be, as I cited, if somebody were to say, for example, I witnessed a murder and there's a video of the vantage point that the person cited that they stood, and then I look at the video and there's nobody there, that would be a big inconsistency that I would seek to clear up. And indeed, I did that here. That's what I meant by that. Something that's glaring, something that you're not able to, something for which there's not a reasonable explanation that can clear this up for you.
You were also asked on cross-examination about who was in possession of the Infinity that was at the Texaco prior to the Donovan Thomas murder. Do you remember that?
Yes.
Why did you say, do you mean, or if you mean actual possession? Do you recall responding
Yes.
regarding actual possession? Why did you say that?
Well, the person that was actually like at the helm of the vehicle and had actual control of the vehicle, not the person that had some sort of legal right to the vehicle through a lease agreement or otherwise.
Did you see anyone else's name on the rental records for the vehicle, the Infinity that was at the gas station up the street from where Donovan Thomas was gunned down?
I don't know. I don't think so. Just Mr. Williams.
Mr. Adams also asked you about phone calls between Demise McMullen, Kenneth Copeland, and Demekion Garlington. In your review of Kenneth Copeland's interviews, do you recall him ever giving a specific time that he was in the car, as in 1 a.m., 4 a.m., a specific time that he was in the car with Demise McMullen and Demekion Garlington?
Well, it was afterward. But no, I don't recall the specific time, or if he cited a specific time. From what I remember, he would cite. Generally, he'd say, "Oh, I think it was around 10:30 or something." That's not a quote at all, what I just said. But no, I don't recall him having like a regimented timeline, like at 1927 hours, we went to this location or anything like that.
Okay. You were also asked about the absence of phone calls in the phone records that you obtained as it related to Defendant Williams and Demekion Garlington. Do you remember that?
I do.
Are you able to tell the jury whether the phone records or the call detail records that you obtained would reflect FaceTime calls?
No.
Would those call detail records reflect WhatsApp calls?
No.
Do you know, or can you even say that there was no communication between Defendant Williams and Demekion Garlington?
No, I can't say that. The records, like I said, the call detail records are only those that were logged by the cellular phone company. A FaceTime call would be facilitated through Apple, the Apple Corporation's platform or infrastructure, rather.
Did you ever charge Defendant Williams with Donovan Thomas's murder?
No.
You were asked about the headliner in the Infinity, or obtaining gunshot residue from the Infinity that you found a year and a half later in a different state. Do you recall that?
Yes.
did you have any information about the number of people who had been in the Infinity between the time that Donovan Thomas was gunned down and the time it was located in a different state?
No. And from what I recall, Hertz wouldn't have been able to provide me with records of that anyway. It's very interesting. I couldn't ask for the rental history on a specific vehicle. I could only ask for the rental history of a specific person.
And did you have any information about the number of times the interior of that vehicle had been cleaned, laundered, or anything else in that year and change?
No, not that I recall. No.
Without that information, why then did you seek to obtain a search warrant?
Well, I primarily wanted to obtain the data from the vehicles, the Infinity's infotainment system, you know, the system that you might hook your phone up to. I thought that if we were able to get a search warrant, we might as well also analyze the interior for gunshot residue. I mean, I was aware of what the probative value of that may or may not be, but I thought better to have it and not need it than the other way around. So that was the rationale there as to why I did that, or was contemplating that. That ultimately never happened.
Mr. Adams also asked you about not getting cell site data for the phone number that you determined belonged to Demekion Garlington, or at least that you testified on cross was Demekion Garlington's phone number.
Well, I don't know that I definitively figured out that that was Demekion Garlington's number. No.
And what information could you get without having probable cause to obtain cell site location data?
You can obtain the subscriber information. That is the information that the phone company has on file for the person that pays for the line, if they have that information on file. You know, the person that they would bill on a monthly basis, basically. And also the what are called call detail records. These are just, I mean, these are anybody who's had phone service, you know, and they've seen a bill and it has a list of your phone calls. Well, that's essentially what this is. It looks a little bit different when you get them pursuant to a legal process like this, but it's just a list of the incoming and outgoing calls and text messages, not iMessages, incidentally, not messages sent between iPhones, but text messages, SMS messages. And that's essentially it. Notably absent from records, call detail records, if you don't have a search warrant, in other words, there wasn't a finding of probable cause, is that tower location data that I've testified to. That is the general area where the handset was, the equipment to which the handset connected to facilitate the communication. Without a search warrant, you cannot get that. You can only get the dates and times of the calls and the numbers that were that were part of that call.
And talking about the lack of calls in those records between Defendant Williams and Demekion Garlington, if two persons or two handsets are next to one another, do you generally expect to find phone calls between those two people if they're sitting, for instance, in the same vehicle?
Well, it's not impossible to call somebody sitting in the same vehicle as you. So I don't know why somebody would call somebody that's saying that. Maybe they can't find their phone. They're like, call my phone, I can't find it. I mean, there could be any number of reasons. I can't speculate as to why you'd call somebody in your immediate spatial proximity.
Who was it that gave you the information about the photograph where Shannon Stillwell is depicted?
Quindary Zachary.
And who was it that gave you the date, or the approximate time or date that the photograph was taken?
Quindary Zachary.
And finally, you were asked about the length of time people remained in jail after being arrested for Donovan Thomas's murder. Do you recall that?
No, I don't recall specifically being asked about the length of time they spent in jail, but I recall being asked about their something along those lines, similar to that, maybe.
Okay. If a person is held on something other than the warrant for murder,
Mhm.
would an MPGJ or a dismissal of the murder charges automatically allow them to be released?
No.
All right, just 1 second.
Sure.
That's all that I have at this time.
All right, is there any recross? All right.
Mrs. Sprinkle, picking up where the prosecutor left off in regards to that NPGJ, what we do know, though, is that Mr. Copeland's NPGJ, the charges or the document that dismissed the murder charge that first put him in jail in 2015, that NPGJ wasn't done until 2017. Is that correct?
That sounds right. I didn't file that, but and I don't recall who the prosecutor was that did, but I was aware of it. But I don't know that he was ever actually booked into the Fulton County Jail on the murder charge, though.
You don't know that?
I don't think. I think he was in the federal jail, if I remember correctly.
The other three were, though, right?
Well, not Mr. Sledge, Mr. Garlington, because like I said, Mr. Sledge's case was dismissed in January 2016. Mr. Garlington, Mr. Jackson, aka Mr. Stillwell, yes.
Well, let me ask you this. You said Mr. Sledge's charges were dismissed in 2016. Where was he before his charges were dismissed?
Fulton County Jail.
Right, so in jail on that murder warrant, right?
Correct.
Okay, so he was in fact imprisoned on Thorpe's murder warrant until until his charges were dismissed, right?
Well, in the jail, not prison, but yes, he was incarcerated. Yes.
Okay, I mean, jail, prison, you're not on the streets. Your freedom's taken from you, right?
Right. I mean, it's a distinction without a difference. I'm just saying that, prison and jail are two different. Yes, his freedom was restricted. He was not allowed to leave. He was in a government facility.
You were asked a number of questions about cell phones.
Mhm.
And I wanted to kind of pick up there. Now, you were aware from the work that you had done on the case, as well as listening to Mr. Copeland's statements, his interviews, that he had multiple cell phones in January of 2015. You're aware of that, right?
Mr. Copeland did?
Mr. Copeland, yes.
I'm sorry. I have one number for him. I don't recall him saying that he personally had multiple cell phones. I don't remember that now.
How about this? Do you remember in an interview that he had with the detectives where on January the 11th of 2015 at about 3:30 in the morning, where he talks to the detectives about his cell phone or cell phones? Do you remember that?
No, I don't recall that. I know I'm familiar with that interview, but I just don't remember him talking about multiple cell phones or anything like that.
Okay. Are you aware that there are no calls? And if we're just going to just talk about the number that you're familiar with in regards to Mr. Copeland, let's focus on that one. all
Okay.
right? Are you aware that there are no calls from Mr. Copeland's per his cell phone records on January 10th, 2015 between 6:58 p.m. and 7:26 p.m.? Are you aware of that?
I don't have the full records in front of me. I do see that the records that I examined, the last relevant call is at 6:58 p.m.
Okay. And you had, when you got his phone records, we've talked before about the fact that you've got the cell tower data. So you had some idea of where you thought he was at particular times based on those records, right?
Oh, I take that back, actually. At 7:01, 7:23, 7:24, 7:26, 728, 743, 745, 749, 751, and 754. There were calls.
Calls
transactions.
coming in or going out?
Let's see, there was an inbound call at 7:01. There was another inbound call at 7:23. There was an outbound call at 7:24. There was an inbound call at 7:26, an inbound call at 7:28, an outbound call at 7:43, an outbound call at 7:45, an inbound call at 7:49, an inbound call at 7:51, and that's it.
Okay. And so having his records, knowing the cell tower data, you were able to opine on where he was at a particular time on that night, January 10th, 2015, right?
Well, his general where the part of town basically that his handset was located.
You placed him, according to your report, either at or near the McDonald's on the evening of January 10, 2015. You remember that?
I do.
All right. Now, you don't have any cell phone or cell tower data records on Mr. Copeland that shows his phone going to what we've called the Sky House on that night, do you?
I don't recall that. Yeah, I don't believe so.
Nothing in your records that refreshes your recollection that you've got any of that. You don't have any of that to show that he went to the Sky House or his phone, the phone that you're saying is his, went to the Sky House on that night. True?
That is correct. I don't believe that. Yeah, just taking a look at my notes, doesn't appear to me that I found that his phone traveled to the Sky House.
And one of the things that you were asked about these phone records, I think the prosecutor asked you, well, the phone records won't show you WhatsApp communications, right?
That's correct.
Asked whether or not the phone records would show you, or said that they would not show you FaceTime communications, right?
Correct.
And so I think your answer, tell me if this is what you said, was that you can't say that there was not any communication between Mr. Williams's phone and, for example, Mr. Copeland's phone on that night. You can't say that because it could have been maybe WhatsApp or FaceTime, right?
Yeah, some sort of platform that for which we just don't have logs.
Right. And so what we have ultimately is that there is no evidence, none, right? Because we can't assume a negative.
Mhm.
There is no evidence that there was any communication between those phones on that night, right?
Correct.
Prosecutor asked you, said, you never charged Mr. Williams with Donovan Thomas's murder, right?
That's right.
You did not,
That's correct.
because you had no evidence that he committed that murder, true?
Well, yes, but I also can't charge people with crimes. I'm not a police officer and I'm not a grand jury. But I think I understood what the question was intended to elicit. And yes, that's correct. I didn't think that there was evidence to charge him.
You, I got a question about a video. I'm not sure if it was a prosecutor that asked you or whether maybe it was Mr. Shard who asked you about a video, specifically at the McDonald's. You didn't get any video from the McDonald's, right?
I did not.
Okay. Are you familiar with different recording systems where there's something recorded and it's kept for a certain period of time and then either recorded over or deleted? You familiar with that?
Yes.
Okay, I think we talked about that a little, or you talked about that a little while ago, right?
Yeah, basically that there's only a finite amount of recording space. So eventually the recording has to start over again.
Now, when we're talking about that, the recording starting over, you said before that some recording systems record for a certain period of time and then maybe a day, maybe a week, maybe 2 weeks, something like that. You remember that testimony?
Yeah, depending on the size of the recording, the size in megabytes of the recording media. I mean, presumably they don't have them on tape anymore. Yeah, it would depend on that.
Right. So if you've got, not hypothetically, but just based on your knowledge and your experience, right?
Mhm.
A system that records every 2 weeks. It's not that you've got 2 weeks of recordings, then all of a sudden that goes away and it starts over, right? Isn't it just that you have one day and then a particular day is taken up by the following day as it starts and goes all the way through? You understand what I'm asking you?
Yeah, I think I understand. It's a hard drive that the data is being written to. So, I mean, I don't know that as the drive fills up, you're right. I guess what you're asking is that after 2 weeks, does all the data just immediately go away at the 2-week mark? No, I wouldn't think so. No, I would think it would be an incremental
Connor.
deletion.
As it relates to this, if there's not knowledge, I would object based on speculation as to any particular.
Sustained.
All right. Mr. Sprinkle, you were asked, I think following up on a question I'd asked you, then the state asked whether or not you were aware of if Detective Thorpe consulted with Detective Dennis or Gaither. Remember that question?
Yes.
And we had talked earlier when I questioned you originally on Cross about the fact that you knew that there were interviews, for example, with Mr. Copeland, where all of those detectives were present, right?
Yes.
And those would have been things that took place after January 10th of 2015, correct?
Yes.
As the murder investigation was being conducted, right?
Correct.
Okay. Then we have the arrest of these 4 individuals on October 20th of 2015, right?
Correct.
Okay.
Well, I don't know that they were all arrested on that day, but that was the date the warrants were obtained.
Got you. That's the date that Detective Thorpe made a decision, and I'm gonna arrest these 4 guys or get a warrant for their arrest, right?
That's right.
Okay. Which he was wrong about, right?
Well,
Sustained.
Okay. You were asked whether or not you thought that, or you knew whether Detective Thorpe sought permission from either Detective Dennis and or Gaither to swear out the warrants for the arrest of the individuals in the Donovan Thomas case.
yes.
All right. I think your response was either you don't know or you don't think he did.
Well, no, I don't think he did. That'd be very odd. The permission lays with the magistrate judge or a judge, not with his coworkers at the Atlanta Police Department. But to my knowledge, no, that never happened.
But what you do know from speaking to the detectives, and by the time you grab a hold of the case, right, is that certainly Detective Gaither and Detective Dennis had been involved to some extent in the murder investigation, right, or at least assisted with it, right?
Yes.
And after Thorpe swore out the warrants in October, they were aware that these 4 people were sitting in jail, right?
They were.
Neither of them, these 2 seasoned investigators, either came to Thorpe or you and said, hey, you know what? We got some problems here. I think we got Detective Thorpe didn't do what he was supposed to do. We need to take another look. That never happened, did it?
Objection, relevance, and vague and compound.
Sustained.
Okay. In regards to the Infinity, we talked initially, I questioned you, not talked, about possession of the Infinity.
Mhm.
And you used the word actual possession.
Right.
Right. You said, no, I do not know who was in actual possession of the Infinity on January 8th, 9th, 10th.
Right.
Fair? Okay. And you were just asked a question about the importance of actual possession. And actual possession is something that's important to you or was important to you in making a determination about the Infinity, right?
Yeah, that's right.
Right. Mr. Williams's name appears as the person who the car was rented to, right?
Yes.
Right. Now, in terms of your investigation, if you believe that there was something that was done or crime committed using the Infinity, right, that is why it would be important to determine who was in actual possession of the Infinity at the time that the crime was committed, right?
That's correct.
Because I can rent a car and it be in my name, but if someone else has possession of the car and is committing the crime, they're the person that's committing that crime, right?
That's correct. I mean, unless I were able to show that somehow the people that actually possessed the car did so with the encouragement of the lessee. But yes, you're right.
And specifically in regards to this case, this Infinity, Mr. Williams, you had no such evidence. True?
That's correct.
Your investigation, I use the term investigation, your work on the case led you to recognize that there were inconsistencies and you couldn't trust what Kenneth Copeland was saying or what he had said in his statements. True?
Well, no, I know. I thought that his statement, there were a number of things that I thought were accurate about his statement.
And some things were inaccurate, right? As far as you knew.
You would have to, his statement was there was a lot in his statement. I tried to look at his statement generally based on what he was able to remember when he provided that 9-hour statement, and primarily compare it with the phone records. And when I did that, I didn't see any glaring, I can't recall seeing anything that was just wholly inconsistent or impossible. Like, for example, the first witness, Spencer Wright, what he said happened was impossible. He wasn't there. I didn't see anything like that with Kenneth Copeland.
Did your investigation on this case, by the time you picked it up or got involved in it late 2015, 2016, seeing everything that had been done or not done thus far, also lead you to believe that you couldn't necessarily trust the investigative work of Thorpe, Gaither, and Dennis?
Well, no. Well, I mean, yes, there was a mistake. Detective Thorpe made a mistake in not taking a look at the video and checking to see if the witness was actually where he said he was. Okay, but would that mean that I wouldn't be able to trust anything in the entire investigation? No, I wouldn't make that sort of blanket condemnation such that I would just disregard everything in the entire file and every finding of fact made by the police. No. I mean, I can see that a mistake was made in one part of the investigation, but there are other parts of the investigation that were not as erroneous.
His mistake put people in jail, though, didn't it?
Yes.
That's all.
All right, any other defense attorney have redirect? I mean, I'm sorry, not redirect, recross? No, you're right. Okay. Okay. All right, Mr. Sprinkle, thank you for your time. I think it sounds like we might see you again at another stage in this case, but you are free to go for now.
Thank you, Your Honor.
And it's a little after 4. Do we have another witness who's going to take hour and a half? If not, we'll just get started with somebody and go as far as we can.
We'll get started with
Okay.
Detective. Yes.
All right. Anybody need a break before we get to the next witness? Y'all good? Okay.
Your Honor, and as it relates to this particular witness, there has been a ruling as it relates to filming.
Okay, so no filming of this witness. Thank you for that reminder. All right, we can go ahead and get that. A quick bathroom, like 5 to 10 minutes. Okay. All right, try to be fast about it. We'll be back at 4:15. And is the first system operational again? Okay, do you need to switch it back over at all? Okay. All right. It's fine, as long as it's not going to cause us problems. And to use the primary system, it seems like it's back up and working again. All right. Well, I mean, you're the one who also wanted the restroom break, but I can listen.
And thank you. So, Your Honor, I'm objecting to a wholesale playing except for what the court redacted from Mr. Zachary's August 5, 2017, 2015 video audio recording interrogation. And there's Georgia cases that I have at my fingertips as well, but the first one is L as in laughter, K as in kitten, L as in laughter versus Ellington, Ellington. Your Honor, it's 2018 United States District Court Lexus numbers 208774, decided December 10th, 2018. And in that case, the district court wrote that the trial court ruled that because AL's statement during it's CAC, but Child Advocacy Center interview were hearsay, and the prosecution had not introduced the interview, counsel could only introduce those portions of the interview where AL made an inconsistent statement, not the entire interview. And that's what I'm saying. Here, the state, and I raised this at your bench 3 times. I said what I foresee is that the state is not introducing the interrogation, either one, there were 2. They're going to not use Mr. Zachary, and they're going to put it up with another witness. And you said, we'll see what happens. We'll see what happens in the future. Well, that's exactly how it played out. And it is my opinion that if there are true then I understand that. And it comes in under 24-8-801 D1A, because it would not be hearsay, because it would relate back to OCGA 24-6-613, prior inconsistent statement. But the state does not have a Kenneth Copeland where he would just say, yeah, I don't remember if I said it, but I lied. They have Mr. Zachary saying, I said that. I am a liar, but I said that. And that's different than the just, I'm a liar, I don't remember, I don't recall. So unless the state can go piece by piece on what is an inconsistent statement, I'm objecting to just having a trial by prior recordings. The state then puts it on the accused and said that, well, we objected to it taking so long, to the state going through the entire interview. The state was asking about, how old are you? Do you have a brother? Where do you live? I mean, all this just page by page, but they did not hit the specific statements that are now deemed inconsistent statements. And I'm objecting to the wholesale playing of a recording and the witness is gone. That's my objection. I have a Georgia case too, and that is Gibbs, GIBBS versus State 340, Georgia Appeal 723. It's in Division 2A, as in Elisa, 2017 case.
All right, thank you. Ms. Love.
Your Honor, I believe that the court accurately surmised that the testimony of Quindarius Zachary was given the way that he testified and what he testified to, much like with other witnesses in this case, he has set up where he has denied with the state information that he gave in the interview. He has claimed to not recall information that he gave in the interview. He has claimed to have lied about specific information that he gave in the interview, even to the extent that when asked identical questions by opposing counsel, he would give a completely inconsistent answer to opposing counsel. For instance, do you know this person? To me, he would say, I can't recall. 5 minutes later, to Mr. Steele, he might say, yes. Or to me, he would say, I can't read. 5 minutes later, he's reading a book placed in his hand. So, Your Honor, I think that the court had it right. I would ask that the court allow us to present to the jury this pertinent information and relevant evidence.
All right. Yes.
I just respond. The part I disagree with is the state has already presented this evidence. When he when he's asked, did you say Shannon confessed? And he says, yes, I did tell the police that, but that was a lie. They've gotten that information out. He has confirmed that he told the police that back in 2015. And that's the whole point of using extrinsic evidence, as I understand it. The whole point of using extrinsic statements or prior statements to prove the point is when the person's denying it and you have to bring in that statement. I'm sure if we look at the transcript, there are going to be a few times, especially towards the end of, I believe, the second day where Mr. Zachary was frustrated and got into I don't recall mode. But other than that, he acknowledged what he allegedly said and said it was a lie, and this is why I lied. And I don't believe that lays the foundation for what the state wants to do.
Okay, so I think that by and large, he said a whole lot of I don't remembers and a fair bit of, if I said that, I don't remember saying it, but if I did, I lied. To the extent that the statement itself can come in as substantive evidence as a prior inconsistent statement. And if the defense has particular parts of the statement that you believe that actually were sufficiently handled such that the extrinsic evidence of that shouldn't come in, then please let me know. But I think by and large, it can come in, subject to the redactions, of course.
Can I respond to your request? He certainly acknowledged making statements about Mr. Stillwell allegedly confessing in both statements. And the reason I can remember that is because I went through them and talked about how they differed. But that was standard impeachment comparing two statements, but at no point did he deny making those statements. So I think that's pretty clear that he did not deny those. He also did not deny giving when I believe it was Miss Love leading, or I shouldn't say that. Miss Love was asking questions and getting into alleged facts that Demekion Garlington allegedly said. I believe that Mr. Zachary acknowledged telling the police about that as well, except he just said that, Garlington was a play. Garlington had given him the play was his ultimate explanation, but I don't believe he denied that either. So I think, sure, there's a lot of tangential points that perhaps a foundation was laid, but on the main points as it relates to Mr. Stillwell, at least, I don't believe that he denied making those statements. And therefore, I don't believe it's appropriate to play the prior inconsistent statements because they are not inconsistent.
By the same token, Your Honor, he also did not deny having said in his previous interview that Mr. Kendrick had admitted to being involved in that murder. He said that it was a lie, but he did admit to having said that.
All right, I'll consider those over the break.
Your Honor.
Yes.
He admitted that Jeffrey Williams, that he said, Jeffrey Williams gave the vehicle to Shannon, allowed Shannon Nard to up drive as well as Mr. Copeland. And he was never even asked about giving Jeffrey Williams a gun, so it can't be inconsistent. Asked about that. Those two items I object to.
Asking about giving Jeffrey Williams a gun.
Yeah.
Give me a
Never
little bit.
asked about that. And it's in his statement to the phone.
About Zachary giving Jeffrey Williams a gun?
Yes. But he never was confronted about that.
Okay.
Your Honor, now that I think about it, he also acknowledged giving to this statement, giving the statement to law enforcement about, well, yes, he acknowledged giving the statement to law enforcement about Mr. Copeland being at Big Boo's house and then saying, let's go, and then returning and learning that there was a price paid on it. He acknowledged saying all that. He said he made it up, but he acknowledged saying all that. And he also acknowledged telling the police about what he observed at the Lil Wayne bus shooting when he was at Club Compound and cars leaving from there. So all those things were touched upon on his direct and acknowledged by the witness.
Your Honor,
Yes, ma'am.
saying that he told the police that and then saying, but it was a lie, makes the prior statement an inconsistent statement. Additionally, he said to the state, I was high on, or I was withdrawing from 3 or 4 different drugs, depending on what time he was talking about it. So his intent was to suggest to the jury any way he could that anything he said about any, and I specifically asked because anything he said about either of the 3 defendants in this case that he talked about, he denied were true. Everything.
Okay. Let's take our 10-minute break, which at this point will bring us back at 4:30. specifically to the, whatever you're talking about with, I guess where in the interview, Mr. Steele, the reference to Quindarius Zachary either providing or not providing guns to Mr. Williams? Yeah, I'm really thinking it's 4:35 right now. Can you go ahead and let the jury go for the day? We'll see them at 9. We can just discuss some evidentiary issues for the rest of this day. They, a couple of them might need to get their things. I don't know if you want to just grab their blankets and things. We will be starting at 8:45. Can't somebody else do that? Because I'm waiting for Mr. Steele to get the reference, so I think you need to be here for that. Somebody else can go say that. But the witness needs to be here at 9. What is it, Mr. Steele?
I believe it's on grant page 149 of 275, line 16, and it's a lot of unintelligible. This grant is not really unintelligible.
No, it's not.
But on this, it says, I told Bud and stop messing with everybody. He might find no guns for no crime. So I know it doesn't sound bad, but I believe that later they say that he bought a gun for Jeff. That's what I'm looking for. And if it's not there, Your Honor, then that's the only reference.
any response on that? I mean, I don't recall that witness being asked anything about that, but it's not really saying anything anyways, is what Mr. Zachary's saying.
Yes.
Judge, I know that the line 19 is out, and I just ask that the court allow us to play it up. What I have is that he said, that I'm looking at it. I know that I disagree with with Mr. Steele about it, this particular sentence needing to be put on him. He said everything he said about each person in this courtroom is not true. And so this is not one of the redactions that were previously ordered. I think
Hang on.
it's admissible, and I'd ask that we be allowed to play up until line 18.
So that's not Zachary saying anything about Mr. Williams, right? It's just him saying, here's what I said to Mr. Williams.
No, it is that Mr. Williams didn't have buy any guns to commit
Hang
a
on.
crime. Sorry.
Okay, go ahead.
Mr. Williams did not buy a gun to commit a crime. That's what it says. It's exculpatory, I understand, but it was not asked about, is what I'm saying. So it's not an inconsistent statement.
Read the entirety of what you think it says
Okay.
for me. Oh, my gosh. Okay. I don't know why they keep opening that door, but it's closed now. I think you said that you thought it said, I told thugs, stop messing with everybody, like, don't buy no guns for no crime.
No,
Okay.
that's not what it says.
What does it say?
Find my page that I lost. Does anyone remember the page I?
Bless you.
Your Honor, it's what he says, according to the audio. It's Mrs. Zachary. I have 149 again. And it's Detective Dennis saying, so they just got sticks on deck, meaning guns?
Right.
No. Where they getting them from? Thug got a check, so it's not, put a date on this and it's unintelligible. Then the next person says thug. Mr. Zachary says thug, and then Mr. Zachary said, I told thug had to stop messing with everybody. He like buy no guns for no crime. That's what it is. Then the next line is out because it's about this
Mhm.
illegal search of Mr.
Right.
Williams' home.
All right. I mean, I think given my ruling, when Miss Love was doing the examination, and I told her, stop going line by line, that I'm gonna permit that to come in. With regard to the rest of your specifics that the variety of you raised right before the break, where Mr. Zachary acknowledged saying something, but then said, it was a lie. That does not prevent that from still coming in as a prior inconsistent statement under 613. I mean, he's given an opportunity to explain or deny. He doesn't deny, he explains it by saying it's a lie. So the prior statement is still a prior inconsistent statement and can come in. So when we start with Detective Gaither in the morning, that'll be my ruling with regard to all of that, that it can all come in, subject to the redactions that were already made under 613. Okay, so a couple of questions about, oh, did we ever get Ms. Love, you were going to provide us with the specific parts of that? Mr. Zachary's Twitter that you wanted in?
So I do have some, but since I didn't push with getting them introduced with Mr. Sprinkle this time, I instead.
Right, but we
I can-
still want to know what they are, so
Oh,
we'll
yes.
know what needs to be dealt with.
Yes,
So
sure.
can you tell us what they are?
Yes, so it was page 32 of 259. And what I'm going to do, Judge, is just scan them all. It's page
Okay.
32 of 259. Page 63 of 259. Page 64. 66. 74. 79. 81. 86. 87. 92. 12, 15, 142.
Hang on, 12, 15, what does that mean?
That's the page number 12, page number 15. I had,
Oh, so we're going back. So before 32, page 12? I'm just confused.
yes, it was. It
Okay,
was, I
so
had
page 12.
just
and-
begun.
All right, and then what?
Page 12, page 15, page 142, page 131, page 128, 129, 127, 126, 122, 119, 117, 100.
Is that it?
Page 3. And like I said, I was scanned these in order. Page 109. 175. 192. 198. original ones in that 140 chronological PDF.
A chronological would be wonderful. And then share that with everybody. And you now intend to introduce these the next time Mr. Sprinkle testifies, which will be how long from now?
Probably not this week, given the, not,
After we get back from our.
yes,
Okay, after the non-jury days.
yes.
Okay. All right. Then that'll be yet another item for us to take up during our non-jury days. Okay, Mr. Steele, I have a question about your motion in limine number 61. In your paragraph 4, you raised the issue of text messages captured on the wiretap. Are there text messages captured on the wiretap?
There are line sheets. There are line sheets
That write in proposed text messages, and I believe that that would be hearsay.
Line sheets that write in what?
So line sheets that the agents create, and they're doing the minimization. And then on that, they have text message and they write what the text message is, but that would be hearsay.
Okay, right, I'm sorry, write that in. There is a text message or the substance of a text?
Substance, the actual substance of a
Okay.
text message. And under the case I cited,
Yeah. I mean, I looked at the case you cited and it doesn't seem to have a holding on much of what.
best evidence rule.
Okay, I couldn't quite tell the purpose for which you were citing that. So you're basically making a best evidence
That's true.
objection to these. Okay. I was trying
That's
to
true.
Sort out what your objection was. Okay. All right, so that'll be something that the state will need to address. But you know what the objection is now. All right, with regard to the rest of it, I mean, I've already made a ruling that the text messages it was just the Verizon person anyway, that they are sufficiently authenticated that you can certainly argue to the jury. And it's ultimately up to them anyway, but it's a prima facie case for authentication and that's been made. And it is not accurate that it's already been proven that those text messages are not verbatim. What the witnesses testified to was that they may or may not be verbatim, not whether they are or not. That it's possible that something might not be verbatim there. But anyway, with regard to authentication, they have been authenticated, so I'm not going to exclude them, and that'll just be an argument that you all can make to the jury. Okay. And then we'll circle back on the best evidence with regard to the wiretap texts. Okay. Your motion in limine 62 deals at this point with Mr. Kendrick's guilty plea potentially coming in and Mr. Ryan's conviction potentially coming in. And I don't know, you know, we had discussed before that if that did happen, that there would at the very least need to be a very tight limiting instruction about that. And I don't know if it is the state's intention to introduce either of those things. And if they are arguing that they can come in against anybody other than Mr. Mr. Kendrick for his and Mr. Ryan for his, or what the argument is. So can you elucidate us on that so that I know what I need to be thinking about?
Judge, I agree that there needs to be a tight instruction, and I just asked for the opportunity to submit a proposed instruction.
All right, but you agree that it's a confrontation clause issue with regard to it coming in against anybody other than the person who was convicted of it, right?
With respect to the plea, definitely, and with respect to the conviction, probably. And I'd like to look that up. I want to make sure, but definitely with respect to the plea, because that's a statement that he's making.
Okay, well, it's equally clear with regard to the jury conviction. So you can look it up if you want to, but it is a confrontation clause issue with regard to it coming in against anybody else. I don't know when that might happen, but
Not before we come back into.
okay. I'm still trying to make a determination. Okay, so I guess that's the only argument right now, is that it's a confrontation clause issue, and yes, it is. So at most, it could come in against those specific people with a tight instruction, and I'll see if anybody else raises anything else.
Okay, and I try to craft an instruction, and I can't do it because I don't believe that it passes intellectually to expect anybody, a lawyer, to really hone in and say, okay, I'll just use this against Mr. I'm not picking on, but Mr. Kendrick for this purpose. And yes, I could use all the evidence against everybody in count one, but not that one piece of evidence, but I'm going to use it against Mr. Kendrick. And by the way, in that indictment, it says the gang YSL, but I'm certainly not going to use that as an admission against anyone else. So I gave up on an instruction.
All right. So, I mean, yeah, there's definitely a potential danger there. So if we don't come up with a good enough instruction, then that stuff can't come in. So it's incumbent upon the state to present something that's workable. All right. And then on the motion limiting number 63, I'm not going to go through the specifics of that one right now. It's pretty detailed. But that's another thing we're going to have to go through. Now, in terms of, and I don't even know if Ms. Good is going to testify or not, but I guess you're not limiting it to Ms. Good. You're saying these portions shouldn't be used with any witness, right?
That's true, unless it's better than, I heard from my cousin who heard from this person. That's how it comes out.
Okay. So now you actually say from asking questions and playing for impeachment, which that's one thing, or to refresh memory. And I mean, if you're refreshing memory, you're just presenting it and they're supposed to be looking at it silently. And I think something doesn't need to be evidentially admissible to be something that could refresh somebody's memory. So I'm,
I was once trying a federal case and the witness couldn't remember. And the prosecutor, U.S. attorney, wrote down a piece of paper in his pen to refresh the memory, and I objected. And the judge sustained it, but said, actually, it does say you can refresh memory with anything, but the judge did still sustain it. But
Well-
my point is, yes, I understand, but it's inadmissible anyway. So I was focusing on some are good. And why would we refresh memory on something that's not admissible? So that's
because
what
it
I
might
was-
refresh their memory.
about something that's not admissible.
So, I mean, they may not then be able to testify about it, but I'm
Right.
not going to limit them in what they can use to refresh somebody's memory.
All right,
And
except
the
for
rest of it we'll take up later.
a lawyer writing it out on a piece
Well,
of paper.
if that happens, we'll take it up at the time, but I suspect my ruling would be the same as that judge's. Okay. I just want to inquire, because it's been quite a long time since I did more than suggest. I ordered the state and counsel for Mr. Ryan to get together on what they could stipulate to and what they agreed, what, maybe not stipulate to, but what they agreed was in and out with regard to all sorts of different evidence. Have y'all done that yet?
We,
Okay, great. So y'all be able to present that when we get together early next week. I'm trying to think what else we need to think about or could discuss or could get out of the way right now.
Have that hearsay, double hearsay matter on
Are
the
we ready
wiretap?
on that? I mean, it's been a while too that we were going to take that. That was, we had kind of gotten stopped on one of the wiretap things. Maybe we won't get bogged down in that right now. So I had asked a while ago for, and maybe I got some of it, but on the unindicted, because they were subsequent to the indictment and allegedly intrinsic acts. I had asked, and I know y'all wrote briefs, but did anybody come up with, and Ms. Abbasi said she couldn't find anything, but has the state been able to come up with any case law where that's kind of factually in alignment? Or,
so not on all fours, but I
Okay.
did find cases that's in terms of the way it's just outlined here, but I did find cases that spoke to the admissibility of overt acts that occurred after and the admissibility of overt acts that were not included on the indictment. But
that was what was in your brief though?
I
Or-
think additional ones. to what
Okay.
was in the brief.
Do you mind just maybe sticking those in an email with the sites and sharing those with everybody?
No, I do not mind.
Okay, that would be wonderful. All right. Anything else?
Your Honor,
Oh.
I just wanted to put a couple things on your radar. I also filed a motion similar to Mr. Steele's regarding witness good. Just so,
Okay, I
that
did
was,
not see that one.
that was filed today. I just emailed it to Ms. Percival.
Okay.
It's been accepted today, but the other thing I was wondering if the state could just tell us where, I assume at some point in the near future, we're going to discuss these Twitter records from Mr. Zachary or whatever they are. I think they're
Right.
Twitter. Could you just tell us where in the discovery they are?
Yeah, yeah, she was gonna resend the link. What's easier?
I sent it to people internally, and they had problems opening it, so I'll.
Okay, do you know which discovery tranche it was shared in?
No, not the discovery tranche, just the link for them, but I know that, I'll do a search in Dropbox for.
Were they served in discovery?
Everything else in the file that it came from, including attorneys.
I don't think they can hear you. Pull the mic to you.
I believe that they were, considering the fact that the entire file that they came from was served, inclusive of notes, internal emails and the like.
Okay. All right. Okay, so if everybody can just do the things that we all just talked about, I'll see everybody at 8:45. Thank you. Yes.
There was one matter that I believe the court had said that we were going to revisit.
What was
No?
that? I don't know.
Your Honor, I just wanted to briefly, when one of the upcoming witnesses is Agent Bernie, who did the cell site tower analysis.
Okay.
And so I think this was back in August. One of the events was the shooting of the tour bus on April
Uh-huh.
of 2015 of Mr. Carter. And so I told the court and defense counsel to give them time to digest that analysis because it happened
Okay.
after that act's testimony. So the state would prefer to, because it's the same calendar year, it's 2015, to walk through those slides with Agent Bernie when he testifies. But I
Mhm.
wanted to, make sure that with the court's prior discussion now almost 2 months ago, before ask him any questions about that. And so I wanted to just raise that now. Your
Okay.
Honor.
Any issue with, is it Detective Bernie? Agent Bernie, Special Agent Bernie, testifying to that incident as well, the phone records with regard to that incident? Y'all had him for a good bit of time now.
I have the phone records. I'm prepared for it, but it is cumulative. But I made this argument to you before, and I believe you said that, or the state said that Agent Racy was challenged as to his qualifications. That challenge was overruled, and he testified fully about it. We went on, and I don't remember how long, but day with the state putting down on a pad in front of the jury all these different calls and all these circles and diagrams that the state brought in. So I still maintain it's cumulative, but I asked you that before, and you said that you would allow him, my memory is you'd allow Agent Bernie to testify, but not to go through the whole thing again. That's how I remember it. And if I'm wrong, please correct me, Your Honor, or anyone else. But I really don't want to sit here again and do the whole thing. And I don't mean that to be curt. It's just, it's inappropriate to keep redoing the same thing because I didn't challenge anything about Agent Bernie for that shooting.
Okay. Y'all understand the parameters?
Your Honor, I do understand the parameters,
All
and
right.
the state's intent is to, with Agent Bernie, that slideshow that I'm referencing, that he conducted, that's going to be the extent. The state's not going to be rehashing ground that was covered with Detective Racy.
All right.
The August 8th, that Dropbox link, it's in Special Agent Bernie's subfolder. No, and what I just sent, Your Honor, to be clear, there was a toll analysis that Agent Bernie did. So there's an Excel spreadsheet that was in that August 8th Special Agent Bernie. The state visually, there's some physical boards printed right behind that witness stand that we did with Detective Racy. It's the same data. Phone X called phone Y for 30 seconds at 7 o'clock. Phone Z called phone S, on and on. So the Excel spreadsheet, those same calls, the same data that Agent Bernie conducted is visually it's being printed on physical boards. So
Okay.
they're not physically built, but I sent the template that our graphics team is putting that information on. So it's the same information. It's just going to visually look a little different than just an Excel spreadsheet.
Okay. All right. So tomorrow we'll have Detective Gaither and then who? Okay. So those will be ready by tomorrow then?
That is, yes, Your
They
Honor.
either will or they won't be.
Correct, Your Honor, correct.
Okay. And then is that going to carry us through the day? Those two witnesses? Okay. And then the next three, this is the same crime scene tech, Jenkins, and then Sanchez and Lewis. And will that get us the whole of Wednesday?
What time did the court say that we were ending court on Wednesday? Is it 5, the normal time?
Normal time.
Okay. We believe that it will, given the length of time that these 2 witnesses are, but if they don't, we would,
You'll be able to evaluate at lunch and scramble and get somebody else.
no, we'll call probably Mr. Sprinkle.
Oh, okay, as long as you got somebody. All right. Okay,
I have the location for where it was served.
Okay.
It was served in Discovery 1-2 back in July of 2022. If you're looking at the consolidated discovery, it would be in folder 1, counts and indictment by act. The next folder, acts 16 through 20, count 2. Then the next folder that says count 2, 16 through 20, discovery 1 to 2. Then the next folder will say social media. The next folder will say Quindarius Zachary, or Zachary, Quindarius.
all right, thank you. And Ms. Love, can you, like, in the next hour to hour and a half, get us the chronological scanned
Yes.
parts that you actually want
Yes, thank you.
published? Thank you. Okay. Okay, and then, Mr. Shart, I'm in receipt now of your motion limiting with regard to Ms. Good, and we'll take that up during our non-jury days as well. Okay, anything else? All right, anybody? All right, I'll see everybody at 8:45. Thank you.